appear, nor has any accommodation been sought for. ঠিক আছে Same.
I'm praying for some time to file supplementary affidavit to incorporate some events after filing of this writ petition has occurred. So I need some time to file supplementary. That
Within which you will file supplementary affidavit.
next week, within next week.
Your name, please.
My name is Mrinmay Mon.
Or
This matter is relating to non-repayment.
have you served?
Yes, my lord, I have served. Long ago, I have served, my lord.
I'm standing. And
ঠিক আছে ওর appearance দিয়ে দেবেন তো Mr. Satansad appear on behalf of the respondent.
This matter is relating to information seeking from the bank authority that in the savings account in the name of my deceased father, is there any nominee?
Have you added the
I have-
respondent as party? Added? Served?
Yes, I have served.
Oh. What is your affidavit of service?
Affidavit of service, my lord, I don't have, my lord. It has not yet prepared, my lord. I have served.
Whether they have received or not, when you have served on
After adding the private
2022. This order was passed in 2023. Monica? The order of addition of party was passed in 2023, but this service was made in 2022.
that, my lord, when the matter was for the first time, it was taken up by the Honorable Justice Moshmi Bhattacharya as a junction. There was, but that time there was a direction to file an application by adding the brothers of the petitioner as a party respondent. In compliance to that order, my lord, I have filed an application being Can 1. But after that, my lord, when the matter second time it was appeared before the Honorable Justice Shobhoshachi Bhattacharya. My lord, then Lordship directed me to granted leave to add the respondent as a party in the main application, as well as leave granted to amend the prayer portion also.
So one bank account was opened by your predecessor, father,
My
by your father. Thereafter, your father died.
Right.
Thereafter, bank is not,
bank is not ready.
whether anyone appointed as nominee.
My only prayer before the bank in my section 6 application as well as my API under section 19(1) of the Right to Information Act, my lord, that is there any nominee in the in respect of the savings account which was initially in the name of my deceased father. But bank was not ready to provide such information to petitioner, my lord. And for such non-reply, my lord, the petitioner preferred this writ petition. And when the writ petition was heard by the earlier justices, my lord, the direction passed, my lord, accordingly I served them copy. But on the next date, my lord, nobody appeared.
On behalf of the bank.
On bank appeared initially.
Krishna Das Poddar.
He appeared for the bank, but thereafter, my lord, he never appeared for the bank, my lord, and no one appeared for the private respondent also. So
Now you want to know how many amount are lying in the account and you want to withdraw or
but not withdraw, my lord. If I file any succession certificate or anything or any probate, anything like that, my lord, I have to know the proper information regarding the account detail, my lord. That detail I only for that purpose that information is seeking by the petitioner.
do you know Krishna Das Poddar?
Yes, he is in. I think he is sitting in Bharat Station room number 30.
So I am keeping it Monday, you give a notice to him. So that order can be implemented properly. Monday. It's Monday. Give a notice that the matter shall be taken on Monday. Monday এটা ওপরের দিকেই দিয়ে দেবে written in
I'm deputy. Order.
you are the for the petitioner. হ্যাঁ ঠিক আছে not today করে দিন তাহলে আর টুকতে হবে না item number 2 okay not today নে
Right, matter number 5, but I am for the petitioner. That if your lordship kindly sees the last order that was passed by my lord Justice Shobhoshachi Bhattacharya, there was a direction, my lord, to serve upon the added parties as well as, my lord, the respond number, my lord. Respond number 4, my lord. So this is my service, my lord.
ছেড়ে দিয়েছে
And the service which was affected upon the added parties, my lord, and the service has come at insufficient address.
আছে হচ্ছে এইটা অনিন্দ অনিন্দ yes.
I may just indicate the fact in short, my lord, the petitioner,
সেই দিকটা
the petitioner before your lordship was, my lord, in possession of a joint license of a excise license. Now, my lord, if your lordship kindly comes to P1, that is at page 16, my lord, your lordship would find, my lord, the licensee's name. Sukhendu Bikash Bhomik, Manik Das, Krishnendu Bhomik. So Manik Das is before your lordship, my lord. Page 16, my lord. And at the very top, my lord, licensee's name C. Your lordship would find, my lord. At the second name, Manik Das is before your lordship, my lord.
শুভেন্দু বিকাশ ভৌমিক মানিক দাস and কৃষ্ণেন্দু ভৌমিক
Krishnendu
yes
The Shukhendu Bikash Bhomik and Krishnendu Bhomik, they have been arrayed in as a respondent in terms of the order of Final Justice Bhattacharya, my lord. Manik Das is the petitioner. But what happened, my lord? But it is a joint licensee in respect of an excise shop, my lord. Now, my lord, the petitioner before your lordship, if your lordship kindly comes to my lord, next page, placed an indent before, my lord, the BEPCO, my lord, for an amount of rupees 7 lakhs. Page 17, your lordship has got, my lord.
7 lakh you deposited.
Now, my lord, the BEPCO, after getting that amount, had sent goods worth rupees, my lord, 4,45,897. My lord, the consignment that was received by the petitioner, your lordship would find at page 20. The bias copy invoice. And the cause of action for the petitioner to approach your lordship is, but as of today, my lord, the license, my lord, has become otious, my lord. Because, my lord, there is a dispute between the, my lord, the parties, but the license has not been renewed. But it has been, my lord, blacklisted, my lord. But the difficulty is, my lord, the petitioner, while placing this indent, had placed the indent from his personal account. The 7 lakh rupees was, my lord, paid from his personal account. Now, my lord, because of the fact that the BEPCO had given goods only worth, my lord, 4,45,897, my lord, the petitioner thereafter prayed for, my lord, returning the remaining amount which was lying with the BEPCO. Now, my lord, if your lordship kindly comes to page 29, but this is the order I am challenging before your lordship today. And the BEPCO says, and if I may place, my lord,
Yes.
in reference to the subject noted above, you hereby inform that your application for returning of the deposited amount of money from BEPCO is not considered for lack of proper signatures or NOC by the rest of 2 other joint licensees of Blue Heaven Restaurant cum Bar, Sri Shukhendu Bikash Bhomik and Sri Krishnendu Bhomik. Now, my lord, the difficulty is, my lord, there is an ongoing dispute between the parties. My lord, they will never give their signatures, my lord. They will never give any NOC in my favor. But my money is stuck, admittedly, but I can show that the money was paid from my own account. And my lord, since 2020, my lord, or 2019, but this money is lying with the BEPCO. My prayer is, my lord, for a direction upon the BEPCO to return, my lord, the amount which is lying with them. But the reason for, my lord, the last order that your lordship has seen, my lord, his lordship was of the opinion, my lord, that the other 2 partners need to be, my lord, be arrayed as a respondent, so that they may come and, my lord, amicable solution may be, my lord, be. But, my lord, they will never come. And they have shifted their place of business, my lord. We have served them the address that we know, my lord, the endorsement is insufficient address. But the difficulty is, my lord, my money is stuck since 2019, my lord. It's 2025. And the license is, my lord, not operative today. And the restaurant has closed long back. This is my
So
case.
you will be satisfied if the direction is given to, upon the respondent to pay 1/3
And
of the amount.
one-third amount will not justify
The
because
petitioner it is submitted shall also be satisfied with a lesser claim of 1/3 of the balance amount.
that was only at the interim stage, my lord. But now as a final hearing, my lord, in a final stage, my lord, I have, well, since 2019, this money is lying with the BEFCO. But this is the 1/3, it comes to at 80,000 odd, my lord.
Maybe it has been deposited by you and it has been credited from your account. But before the authority, it was deposited in name of 3%.
No, man, the money was credited from my
So
account.
for their prospect.
Right.
Now today, if they release entire amount in your favor, tomorrow others came
They can come
and
they can
stake a
basically-
claim.
I know,
Then
my lord.
what will happen?
But for that purpose,
Then
my lord,
what will happen?
I know, my lord. And for that purpose only, my lord, they were, my lord, supposed to be added as a respondent. They were added. They have been served. But then they have shifted their place of business. I don't know what their current addresses. But kindly see the endorsement, it's say insufficient address. But they will never come and they will never give the NOC in my favor. It's a peculiar situation, my lord. I know, my lord, why your lordship is thinking, my lord, that I am entitled to the 1/3 of amount. But it is also admitted, my lord, that the money was credited through my personal account. The document is there before your lordship today, my lord.
Maybe what was your personal arrangement before making payment, it is not known to the officer. It is not to the. You kindly consider from their perspective. And today, if they release entire money in your favor, tomorrow your mother will come and stake a claim.
Absolutely.
Then what they will do? Now what is
No, we cannot help him. My lord, today it was a joint license.
now whether
Well,
if
this is beyond
if
the.
he submit the bank guarantee in respect of the rest amount,
He has to get a decree. My lord, like someone told my lord, the previous some decree or some endorsement from a court where the dispute is going on. My learned friend said the dispute, there are some litigations are going on. He has to get an order from that court.
And that dispute is something linked to something else, my lord.
And we do not
this.
know. And we do not know. That is the difficulty, my lord. This, my lord, this is something, my lord, subject to correction. It's beyond the scope of the excise authority. Excise authority does not see any individual. It was a joint license. Whoever pays, my lord, we cannot help. Today, my lord, that's why the order. And my lord, if he has not served, if it is insufficient service, it is not a good service. Ultimately, it's not a good service. My lord, it's not his service. When he was asked to serve to others, he says he has served to an address where it is found as endorsed, has come back as endorsed as insufficient address. Now, that is not a good service.
Candidly submit before your lordship.
That is not a good
Because they have
service. My
shifted
lord,
their place of residence.
right,
My lord,
he has to, my lord, he is the petitioner. He has to ensure that the service is made.
so you have to find out you are say what is called dominant litis. You are come here, you have come here in court to get a relief. So it is your duty to effect service of the of your pleadings or application upon them, and
may I
you
make
have
a
to
fresh-
find out their current address.
In that context, my lord, may I make a fresh endeavor to serve, my lord?
Yes, that would be better.
Kindly grant me some time, my lord.
Actually, record reveals by an earlier order 3x means
Honest calculation.
ওকে মে মাসের মধ্যে হবে।
এই তো বাজে মত দিতে
Okay.
এটাই
হ্যাঁ, good.
হ্যাঁ
Yes, next.
Number six,
My lord, I am for the petition.
I am appearing on behalf of the respondent number 6 to 10.
My lord, one supplementary evidence.
Copy has been served.
But we have seen, my lord, let us see if your lordship can.
Have you seen?
You have seen the content,
But we have seen.
the one-page supplementary affidavit, my lord will kindly take note of.
This is- Supplementary affidavit to bring what?
For your lordship, is the window of a landed public
Okay, supplementary affidavit verification. তাহলে ইয়ে করুন, supplementary affidavit as filed on behalf of the petitioner is taken on record.
petitioner has come before this honorable court to direct the on administrative part to direct the district magistrate to find those bills and submit those bills to the TM office for payment. And during the pendency of the writ application, that to kind of look into the supplementary affidavit. The on administrative part, Landed district judge already, my lord, forwarded those bills, my lord. Now, my lord, with due respect, I'm submitting, candidly submitting, the petitioner got some amount after the filing of this writ petition. And my lord, now, lordship kindly direct the district magistrate to remaining amount to disburse the remaining amount.
How much you claim?
My lord,
You claim?
that is
বলেনি amount বলেনি
amount, my
What
lord,
has been specified?
not specified, my lord, that is on the bill, my lord, the admitted amount, if any, my lord, remaining, lordship kindly direct the authority to disburse the amount.
may I
হ্যাঁ
may I my lord?
হ্যাঁ
My lord will kindly come to page 19. So this is his letter, my lord, to the district judge. My lord will kindly take note of the last paragraph. In view of the above, I once again humbly request you to kindly process the much needed verification procedure of the what register, which will enable me to submit my bills before the district magistrate. Now, my lord, his claim in the supplementary affidavit is after filing of this writ petition, the district judge, the learned district judge, has, my lord, endorsed endorsed the verification procedure for 44 bills. If I have understood rightly, my lord, the annexure to the supplementary affidavit speaks of that, my lord.
yes.
So, my lord can, subject to my lord's kind approval, your lordship can direct the district magistrate that, my lord, if the district judge has verified those bills, there's no point keeping them pending. My lord will kindly direct disbursement of same. My lord, subject to the condition that it has been endorsed and or verified by the district judge. হ্যাঁ এই থাকলে তো দেবে না জানি কোথায়
The widow of
রেকর্ড থেকে
kindly give me the, within half an hour, I submit the original, Xerox copy, not with me also, supplementary evidence. Within half an hour, within 15 minutes.
Oh, okay. দিন দিয়ে যাবে। আজকে হচ্ছে আপনার 16/4। জাস্টি দীনেশ শর্মা কি নেয়? Yes, next.
Number 7.
Shogata Mitra supplementary before petition and
Not this week. Okay, not this week.
Number 8.
এই দেখি কি আছে 22 সালের মামলাগুলো। একবারও অ্যাপিয়ার করেনি তো এটা। ওকে একজন মোশন হিসেবে দিয়ে দেবেন, এটা একজন মোশন হিসেবে কালকে কালকে দিয়ে দেবেন। তারপর
Order. Number 9.
Item number 9, I am appearing for the respondent, my lord, my lord. Learned advocate is, my lord, is out of station, my lord. My lord,
হ্যাঁ,
it's out of station, my lord. My lord, kindly keep it.
the petitioner is not there,
Yes, my lord.
they are not interested. দিদি ওনার নামটা লিখে give your name.
Yes.
দিদি আচ্ছা না না yes. What? 125? Huh? Section 125 has been challenged by which court? Did he? This be for default? Let it be calm. Huh? One day let's say Monday fixed. It is not Monday. So Monday? Monday. Huh? Because today, today and tomorrow, Lordship. Oh, okay, Monday. My lord, I must say, my lord, 2 hours. Yes, yes, yes. Yeah.
11.
It is not this week. Huh?
I am appearing on behalf of the petition, well.
Huh?
2 hours, well.
Yes. 2023. Cancel from the impugn notice.
The fact of this case is that
13/7, yeah, you want.
have filed a writ petition before this honorable court.
Hmm.
For being number 233 of 2022.
Huh?
2022, he has filed a writ petition against my client, that is the petitioner here, for encroachment, for alleged encroachment and alleged unauthorized construction allegedly made by the petitioner herein. My lord, thereafter, Honorable Justice Subhra Ghosh has been pleased to pass an order. I'll kindly look into the page 18 and 19, my lord. Directly the respondent number 6. To hear the petition after directly respondent number 6. To consider and dispose of the said representation within 3 months from the date of receipt of thereof, and affordable reasonable opportunity of hearing to all interested parties, including the petitioner therein and the private respondent therein. The petitioner hearing in accordance with law. My lord, thereafter, on 13 July 2022, the assistant engineer HON'BLE Highway subdivision issued a notice without giving any reasonable opportunity to the petitioner hearing. I'll kindly see the page 20, my lord.
Yes,
Without giving any reasonable opportunity and focus. So you are kindly see the paragraph. It is reported to you. May I be permitted to read, my lord? Focus notice, my lord. It is reported that you have encroached some portion of the government roadside land by the constructing the kacha and paka structure 41 inches into 21 inches.
so why you have challenged the notice here?
My lord. Thereafter,
If assistant engineer pass any order, there is appealable order before the SDO, you go over there.
kindly see. Thereafter on
Who is for the state?
thereafter
Who is for the state?
I don't know, my lord. My lord, first
You serve upon them, okay? You take information who has been interested yeah, with the job of repenting the state, okay?
has admitted by the authorized decision Moshumi Bhattacharya. Kindly see the order.
Maybe, but you serve upon the state. You know in the meantime whether assistant registrar has passed the order or earlier occasion, no. I am keeping in the next week, you serve upon the state, intimating that the matter shall be taken up
Kindly
on to 21st.
kindly give necessary order, my lord, so that I can serve.
Huh?
Kindly your lordship may pass necessary order. I will serve the office of the GP.
Also, having heard the learned advocate and upon perusal of the
Yes, accommodation, Lordship.
okay, not this week.
Lordship, grateful.
Number 13,
13, my lord, I'm praying for not today, my lord. Can it be taken up tomorrow, my lord? Mr. Indranil Nandini.
Matter no matter. Tomorrow you will do.
Tomorrow, my lord.
Okay, not today.
Grateful, Lordship. Happy no,
Tip number 15.
15 দিন। একজন মোশন, তার মানে কেউ আছে আসছে না। আসুন। None appears on behalf of the respective parties, nor any accommodation has been sought for. In view thereof, did it. দিন।
17.
17, my lord, I am for the petitioner. Here the interim order will expire today, my lord. Initial interim order was passed on 16th of December 2022. Subsequently, it was extended from time to time. Affidavits have been complete. In the matter, it's ready for hearing now.
Malan.
Prosecutor can extend the interim order and fix the matter one week after vacation.
Oh,
Some settlement is going on, but I came to learn from the department.
or talks of settlement is going on.
Going, my lord.
Not in my yes, it's a project of JNR buses.
Oh,
That is why there the number of operators are there. That's the government wish to settle that. Inquiry to show that the commuters at large cannot be suffered.
আচ্ছা, আচ্ছা।
That is why.
Lordship can fix the matter any day after the petition.
আর so আমি করুন ওই had the learned advocate appearing for the respective parties. Stop.
My lord, 18, I appear on behalf of the petitioner. My lord. My lord, in this matter, my lord, we challenge the suspension order issued by the SRFTI. My lord, there is a stay upon the suspension order by the coordinate bench. My lord, not only the suspension, my lord, there was a suspension pending inquiry which was going on. And
Affidavit complete.
my lord, affidavit has been filed by the respondent. Our affidavit is not complete only to the fact, my lord, the petitioner is undergoing a surgery, my lord. She will be back after a week. So, my lord, I will require 2 weeks time, my lord, to affirm and come back. Last order was on
It has
21st.
come up under the heading extension of interim order. Your lordship kindly extend the interim order for a limited period.
But the last order was on 21st March 2025, my lord.
আচ্ছা। Had the learned advocate representing the petitioner. Stop. আচ্ছা, petitioner submits that a copy of the
On the last occasion, there was a direction to serve the copy of the notice upon Mr. Bormann, Lordship. Affidavit of service. What happened, Lordship?
affidavit and reply given.
It is ready, not yet affirmed. Lordship,
You are appealing for the respondent.
Yes, my lord. I was all along there, my lord. Unfortunately, last occasion I missed this matter.
Oh,
on the last occasion, when the matter was in the last writ petition, which was heard before this honorable court, Lordship, the Honorable Justice Jayanta Kumar Biswas was pleased to set aside the penal order.
This is
passed by
my
the-
lord irrelevant, my lord. Perhaps my learned
No,
friend is
that was
supposed
set
to
aside, Lordship. That was set aside.
supposed to
What
file
the
affidavit
in
and
other
reply.
cases-
I have not been
What
served with any affidavit in reply.
What
I do not
Lordship,
know
that
whether
affidavit reply has been prepared since the petitioner is ill. It could not be affirmed, Lordship. That is not at all necessary because everything is supportive, Lordship. Everything is on the
whether
basis
you
of the,
want to
Yes,
use affidavit
yes.
in reply or not,
that will be used, Lordship.
then
you will use.
Within a day or two, let me hear, Lordship.
no, my lord.
It's a
I
use
oppose
of,
my lord. I
use of
oppose my lord.
wasting judicial hour. If you want to use affidavit
Right.
in reply, you use it, take time, and then yeah,
Only
it
2
would be
days time
taken up.
is required, Lordship. Let it be fixed on Tuesday, Lordship. Tuesday, Lordship.
In the
I am
coming
ready.
week,
I am
in the
ready with the
coming week,
entire matter, Lordship. What matter is very
I
short.
have
Now
some
it is very
some
short.
difficulty
In
in the
the
coming week.
Lordship,
Let
on
it be
the
two
You
after 2 weeks.
decide what we will do. Will you proceed, ask the court to proceed without your affidavit in reply, or you will take
Then
time to
1
file
week time,
affidavit?
So,
Yes, 1 week time.
1 week time, Lordship.
after 2
1
weeks.
week. No, not after 2 weeks. Lordship. Only 1 week.
My learned friend is taking time now. She is
Only
standing
1
in my
week,
way.
Lordship.
No, not
I am
1 week. She
Yes,
has got,
fine,
if I am
Lordship.
not mistaken, this is the third opportunity my learned friend is getting
I am
for
ready with
for,
the
for
matter,
filing
Lordship.
affidavit in
He is
reply.
ill.
And when I am seeking
Could
2
not-
weeks time, she is saying no. This sort of
Only
practice should
2
not
days
be
time
encouraged.
is required, Lordship.
So within 3 days you will file.
Lordship. Within 3 days I can file, Lordship.
अच्छा ये ये कौन अच्छा
Kindly fix it after 2
विशेष
weeks.
चट्टोपाध्याय
No.
हाँ?
No.
Kindly
No,
fix
Lordship.
it after
Matter is
2
very
weeks.
short, Lordship.
I have
Matter
few
is very short, Lordship. But petitioner is 74 years of age.
Okay,
age,
it will be taken
penal
up.
order is there, Lordship, on the basis of the inquiry, Lordship, on the
Kindly,
he was exonerated of the charges.
kindly see
Lordship.
how many
the
occasions
penal
my
order
learned
is-
friend has taken time for filing affidavit in reply. Now she is saying a short matter. Kindly see how many occasions. I generally do not oppose, but this kind of my lord,
In the month of March also you
He
take
is
time.
ill, he is
if I am
ill,
not
he is
mistaken,
ill.
at least
এই সব ভর্তি করে ফেলেছি তো না 30th April. Place the matter for further consideration on 30th April.
Lordship.
30th April?
Lordship.
perhaps my lord.
Oh. Yes. Next.
Matter number 20.
I appear for the petitioner in this matter.
my lord, not this week, my lord. Mr. Bosu only appear in behalf of the state respondent, my lord.
I have no objection.
Okay, not this week.
Not this week.
Grateful, my lord.
But next matter also not this week.
Okay, not this week. 20 and 21.
Yes.
21 or? 21, my lord, perhaps your lordship has no determination. My lord, I have problem.
No.
Lordship,
20, sorry, I'm 22.
Oh,
21, perhaps your lordship has no determination. It's a 24 writ petition.
it is 24 writ petition. So it
Perhaps
released
I
from
do not
one
know,
of
my lord.
24 writ petition.
Lordship, I'm appearing in item number 21.
Yes, 21.
21, he is appearing, your learned friend is appearing virtually.
Lordship,
Yes.
Lordship,
It is a repetition of 2024.
2024.
2024,
My determination is up to 2022.
15.
2020,
Uh,
Lordship,
So,
Lordship.
so release,
Determination
release
code
for
number
want
2.
of determination. Release.
File the affidavit, my lord. There was
I have no determination, so even.
My lord, I am appearing for the Union of India.
Lordship, in that
Okay,
event, your
সবাইকার
Lordship,
নাম লিখে দেবেন দিয়ে আপনি লিখবেন যে the writ petition is released
The
from my
Lordship-
for want of
Lordship,
determination.
then I have to mention something, your Lordship.
Yes.
This earlier, since it is a 2024 writ petition, Lordship may kindly seize if it is in that event, the 2024 writ petition, the earlier order was passed by your Lordship without 19th March 2024. Your Lordship has 2025, 19th March 2025. This similar writ petition was taken up by your Lordship, wherein the directions for affidavits were extended. Your Lordship, in that event,
At
your
that
Lordship
point
had-
of time, your lordship had the determination in court number 551, 654.
and Lordship,
That time it is a new from first
That
April.
determination was there.
the
Today,
difficulty
your
is
lordship
that,
has no
Lordship,
determination.
Lordship, even
Before 1st April, I have determination in respect of irrespective of classification and irrespective of year.
Lordship, but the difficulty was that even if the matter was mentioned before your Lordship, I'm appearing for the petitioner. I was never served any notice. The extension was granted without serving any notice upon the petitioner.
Well,
Lordship, may kindly
she
see
did
the
not
last
appear
order.
and on that time. She did not, matter was in the list.
Whether it is affidavit, it is a hearing matter.
Yes.
Lordship, hearing matter.
Hearing matter, so whenever hearing matter irrespective of classification 2016 and onwards.
For
Why it
2016.
is not within my jurisdiction, within my
2016.
determination?
Then your lordship has the determination.
Huh?
Then your lordship has the determination. If it is
2016 and onwards.
onwards, yes. Then your lordship has the determination.
So,
I appear for the respond number 3. In this matter, we have
Lordship,
filed an affidavit.
Lordship, may kindly takes the
That
last
may-
order.
Mr. led by Mr. Jishnu Shah is there, madam. Mr. Shah is leading me.
yes,
Well, may I file the affidavit in that case?
yes.
Lordship, this affidavit's directions were passed, your Lordship. The first day when the matter was taken up, directions for filing of affidavits was given till the month of August. Thereafter, an application was filed for modification in the modification in the order. Subsequently, the extension was granted to the respondents to file their affidavits till the month of September. Now, this third time when they have sought for the extension before your Lordship, my humble submission is that, your Lordship, to the best of my understanding, a notice ought to have been served upon the petitioner.
Well, the matter was in the list, I am told. I, of course, my lord, I'm on the instructions I'm saying.
Okay,
Matter was
now the copy of affidavit service, affidavit in opposition has been served upon it.
Has been served after a very long time, beyond the date.
Okay. Madam, don't raise such sort of technical plea.
Lordship, the
Okay, it
difficulty
gives
is that,
an impression upon the judge that you have, on merit you have no case. Okay.
Lordship, before we can
Take-
go into the merit, the extension has taken 3 times.
Okay, you accept it. Will
They have
you use affidavit in reply?
Lordship, I will. Lordship,
Or
what has happened?
when you will file?
Lordship, prior to that, since the opposition was not served, the order which was also passed, which was ex parte, was also not communicated to me. In the meantime, I have filed an application. Lordship, that is Can 2. Lordship, may kindly takes up Can 2.
Can 2 is still pending.
It is filed. It is just recently filed.
Can 2 for
Can
what
2
is the
there.
application for? Can 2?
It is filed on 7th April 2025.
For what purpose?
Lordship. Now, your Lordship, this matter, when it was heard, it was pursuant to an order passed by the
এই ক্যান 2টা কোথায়? বাবু তন্ময় ক্যান 2 কোথায়?
Can do copy survey, no survey. Copy of
সব দেওয়া হয়ে গেছে copy.
ক্যান 2 আছে? The can 2 is not with the record.
Lordship, I have filed, your Lordship. Lordship,
Okay, you give a copy. Let them find out. আপনি খুঁজে বার করুন. Give a copy.
Lordship, this is my Can 2.
Yes, give a copy.
এটা দাও, okay.
Why this?
Lordship, today the
For
instant
appropriate order.
Lordship, today the instant writ petition is appearing
Whether
Along with
can it be not taken up along with the main petition?
Lordship,
to
no,
be-
Lordship,
Huh?
kindly appreciate, your
Oh,
Lordship.
If your lordship allows
So
can to, then your lordship will be allowing the writ petition itself.
yes.
Kindly,
I say that it is beyond the prayers in can to are beyond the scope of the writ petition.
Lordship, I have filed this application to bring on record, your Lordship. The uniformity ought to have been maintained in respect of all. Not only in respect of these 5 petitioners, but in respect of
That is
all the employees, your
beyond the
Lordship.
scope of the writ
Lordship,
petition as
kindly
filed.
takes up the can to on Monday.
Can to is required to be taken up first.
Lordship,
Why? So I am to apply my mind regarding the issue.
Lordship, that was the
involved in this
difficulty I was trying to place before your Lordship.
1 minute, 1 minute.
If
You
I-
want ultimately you want subordinate to protect the prey drawn by the petitioner upon extension of device, entry level scale such and such, and upgradation of it.
ওটা আমার copy.
So what happened? Your pay was wrongly fixed.
Wrongly fixed, your
Fixation of pay was erroneous.
Lordship, not that. Lordship, not that. There was a particular notification pursuant to which all the employees of the port, be it the dock pilots, dock masters, whoever it is, class 1 employee, all of their pay scales was to be made uniform pursuant to one memorandum, which is part of the writ petition and also of this can. Lordship, what has happened earlier, 2 writ petitions were filed. With respect to the other writ petitions, I have obtained an order from the earlier Honorable Court, before Honorable Justice Arindam Mukherjee, wherein the reliefs granted to the writ petitions in WP such and such is to apply in case of the writ petitioners of 13684, which is before your Lordships today. This was my relief. Now, when the same has gone before the authorities, the port, your Lordship, they have decided to give it in a piecemeal manner. They have decided to give it to 2, and with regard to other 2, they have not taken any steps. So on that regard, I have filed an application. Now, what Lordship I was trying to explain, it was not on the technicalities. It is that if the time for filing of the affidavit could have been informed that we are extending, we have sought for an extension of filing the affidavit, your Lordship, because that has come to me after I had filed this application.
So come to the merit. So you are claiming to be a candidate similarly situated of that writ petition.
And I have also fetched an order.
That benefit has not been extended in your favor.
Full, my lord. I will
It
be only
is
seeking
your
that much.
your
Yes.
main grievances.
Yes, and then the writ petition can be heard any day upon
So
exchange
what-
of affidavit.
what-
That is the writ
It is a
petition.
subsisting interim order.
I am praying with regard to the interim order only.
My lord, my learned friends had sought
I'll be
modification of the
and I'll
interim
be-
order, that was can 1.
Using a reply because they have sought for extension of opposition without my presence.
But then the other set of petition has been given to them.
I have a matter to argue on merit.
Okay, subsequently courts required their stand. Court requires to know the stand of the respondent
Lordship,
in
that is
respect
not
of
there.
the petitioner averments. Okay.
Lordship,
Hmm.
Lordship, I'll be humbly praying, Lordship, first take up the can application.
So
That is my
can
only
what
prayer.
interim order?
Interim order,
require?
Lordship, then I have to place the order.
If any pay scale is given by virtue of an interim order, that will complicate the ultimate result, may complicate. Then another revision is required.
Lordship,
And
in that
let
event,
the entire dispute finally settled.
Lordship, then in that event, there are other 2 writ petitions that has also to be heard along with this. Lordship kindly takes the order because there are other 2 writ petitions also. This
Filed by you.
No, filed by the filed by the other advocates. In respect of
But they are
similar-
not approaching this court.
Lordship, in
They don't want judicial
Lordship,
determination of their issue
my order,
by this court.
Lordship
What-
kindly
what- what
appreciates,
will do?
my order is flowing from the earlier 2 writ petitions.
That is
And
a matter
those
of
2 writ
record. If it
petitions
is
were
there,
taken
You will
together.
you will produce the copy of the order passed in that writ petition.
Lordship,
Okay.
Lordship.
If I find there is any reason to agree
Lordship.
with that order will be passed. If I find that I will disagree, then
Lordship, with what has
Another
fallen
steps
from
shall
your
be taken.
Lordship, with regard to,
already in the record.
this is already with the record, Lordship.
So-
Any day, Lordship
so
takes
why?
up the matter.
Order, she's got an interim order.
Lordship, based on.
Or if you want, let the matter go out of the list. Let
That cannot
let
be
that
the
court
relief.
decide the issue first. Then you mention. or I am releasing this matter, let this matter placed before
Lordship,
that
that
bench.
will not entail to the benefit of the petitioners, your lordship. Today they are affected, your lordship. Today they are affected, they are, lordship.
There would not be any impediment to dispose of this writ petition independently. Because the ownership has been appended to the writ petition itself.
That is why, what I am also submitting, my lord, your lordship may take the writ petition, dispose of it, because my learned friend relies on those orders, my lord, in the writ petition.
So it would be better, you file affidavit in reply,
Lordship.
come on that date, I am fixing a particular date, come with that, you controvert or deal with the averments made in their affidavit in opposition, and the writ petition as well as your application would be disposed of simultaneously.
Lordship is keeping
That
it for
would be
final.
better for you.
Lordship is
And
keeping
don't
it for
take
final
any
hearing.
interim order in respect of pay scale. Let the issue be settled finally.
Lordship.
It will create further
Lordship,
conflict.
that event, Lordship, in that event, if I may place your Lordship, that since the other two writ petitions, Lordship kindly pardons me from repeating the same. Lordship may kindly direct those other two writ petitions to appear along with this.
Petitioner is not approaching. Petitioner does not want judicial determination of their issue by this court.
Lordship,
What
it is
court
the
will do?
similar issue. Lordship, it is the similar
Yeah.
issue.
I don't think my learned friend will face any problem, because
Yes.
whatever orders have been passed on those writ petitions, my learned friend relies on those orders in this writ petition.
Yes.
So, my lord, those writ petitions need not be heard simultaneously or along with, or my lord, side by side, or one after the other. My lord, this can be
Yes.
heard and considered independently.
Lordship,
So
Lordship.
this court takes notice of that order passed in that matter. Okay. আর ইয়ে করুন তো আচ্ছা ইয়ে আপনি ইয়ে করে দেবেন
আমার এই ওটা আমার অফিস কপি।
আপনি ইয়ে ওনার নাম কি মিস্টার
আমি দেখে নিচ্ছি।
ইয়ে প্রেস ফর
আছে
এক্সটেনশন অফ টাইম ওনার নাম কি জানো
কোর্টে ফাইল হয়েছে তো ওই জন্য ওখানে আছে।
সাহা জিষ্ণু সাহা
হ্যাঁ তাহলে ওপরে গেলে হার্ড
পাইনি দিয়ে
the learned advocates representing the respective parties. ঠিক আছে স্টপ মিস্টার এনার নামটা বলছি মহিলাটা আচ্ছা মিস ঘোষ learned advocate representing the petitioner pays for extension of time to file affidavit in reply to the affidavit in opposition filed on behalf of respondent number 3. Stop. Acha, pair is considered allowed. Acha, let such affidavit in reply be filed within 3 weeks. Acha, leaves the matter for further consideration. On 15th May. On 15th May. ঠিক আছে?
My lord, could it be, my lord,
Yes,
15th and 16th, my lord, I find I am in some difficulty.
16th.
But,
So 19th May.
19th May.
19 May. Okay. It will be on 19 May. Yeah. Next. 22.
Mala, I am for the petitioner. For Mala, I am file exception. I am praying for.
They have not filed their exception.
Mala,
Report is on record.
Yes, we have filed it last occasion. They were supposed to file the exception that has. the
Acha,
exception
Mr.
has not-
Bhattacharya, learned advocate representing the petitioner pays for
I am for the petitioner, mother.
I served a notice, but earlier on 20th March 2025, my lord, Mr. Partho Bhanjo Choudhury is appearing for the company. It's a dismissed employee, my lord, challenging a disciplinary proceeding, my lord. He filed this writ petition. My lord, your lordship kindly make it not today and not tomorrow. Let me serve a notice upon Mr. Choudhury.
Okay, not this week.
Or
I am for the petitioner led by Mr. Parthabotin Roy. My affidavit of service.
All are sub.
My lord,
All
at
of
that point of time, it was served in the year 2023, my lord. At that point of time, all served, and
My lord, I have served a notice upon the learned advocate appearing for the state respondent, my lord.
Recently or earlier occasion?
That is, my lord, on 7th April 2025, my lord. It is not, my lord, affidavit of service has not been prepared, my lord. This is my original affidavit of service, my lord.
अच्छा देखिए दिन है ठीक है what do you want?
My lord, this is pursuant to, my lord, earlier order by this honorable court at page 52, my lord. The concerned district
One minute, I am coming. You have challenged the order of district magistrate.
Yes, my lord. That was
And
passed.
to remove the member of 4 self-help group from discharging their cook elder in the madrasa. Who are you?
My lord, I am we all the petitioners are the cook come helper, my lord. We used to run my lord, the entire midday meal project, my lord. And thereafter, my lord, one notification was there by which, my lord, the honorarium was directly supposed to pay in our account, my lord.
1 minute, I am coming. In
Fine.
view of the above, block steering come monitoring committee directed to observe work of each such and such very closely and keep them engaged or terminate on the basis of periodical evaluation of their performance in accordance with the provision as mentioned in the modified earlier. Yes.
My lord, now, my lord, the order under challenge.
Now
my lord,
you are one of the 12 petitioner.
Yes.
Yes.
All are, my lord, who come helper in the school.
Huh.
In a particular school, my lord. When, my lord, the 4 self-help groups, respondent number 9 to 12, are engaged, my lord. We belong to, my lord, a particular, my lord, one self-help group, my lord. When, my lord, when the work was started, my lord, we were not paid honorary. We made representation, one memo was issued, my lord, that honorarium will be paid, my lord, directly to our account. Thereafter, my lord, problems started, my lord. Thereafter, these 4, my lord, group were engaged, my lord, for the purpose of, my lord, executing this midday meal program, my lord. They stopped payment to us, my lord, and they are restrained us from doing our work, my lord. Thereafter, we approached this honorable court, my lord. There was one representation, my lord, my lord Justice Devanshu Bharshak on 5th November 2016 was pleased to direct the concerned DM, my lord, to consider our representation, my lord. Pursuant to that order, my lord, a hearing was conducted by the DM, my lord. Everything was there except considering, my lord, our case, my lord. If, my lord, sees, my lord, a report was called for, my lord, and from the concerned block development officer Habra 2 at page 54, my lord, will find that. From the report, each and every observation, my lord, has been recorded on the date 2nd February 2017. Thereafter, on 8th February 2017, my lord, it is recorded that all the 4 self-help groups are functioning there, but with regard to our engagement in the said project, because, my lord, we all are belong to minority group and we all are the poor, my lord, women. So there is no whisper, nothing, my lord, has been recorded with regard to our engagement, our work, my lord. The purpose of considering representation, my lord, has not been complied with, my lord. Is for the sake of compliance of the honorable court's order, my lord, this order was passed, my lord, without addressing our grievances, my lord.
So initially, yeah, you are the member of 4 self-help group.
Out of them, one, my lord, we were attached to only one group, my lord. That is
No,
the
no,
first-
it was stated that it was decided that taking three members from each group, 12 person was selected who are working for the last 2 years. Acha. Thereafter, the problem started when with the Upasangher Sampadika, one Jakira Bibi, ICDS is a government employee of ICDS school. Then high madrasa, London Communal, yes, they withheld the payment of
our honorarium was withheld by the authority.
by them.
By them, my lord. Not the authority, my lord, that self-help groups, my lord. Respondent number 9 to 12.
They have
They have withheld our, my lord.
withheld. That's a
Withheld our
honorary. Yeah.
My lord, may I suggest one thing, my lord?
1 minute. No, it's right. So you are member of four groups, not any particular group. So you wanted so that the money you work up to 12 members, these 12 members continue to work up to June 2014. Still you are working.
Thereafter, we were not working, my lord. What was decided, my lord, that alternatively each group will, my lord, implement this midday meal program. So our engagement were not there, my lord. They are from that day, my lord. We approached this honorable court, my lord. That was, my lord, decided by Honorable Justice Devanshu Washak at page.
They pay up our dues.
Yes, but for engagement hour, my lord, because we are not in that group, my lord. Now, our, my lord, services should be, my lord, regularized in the form of, my lord, so that we can continue with our work. My lord.
No, in your 9/6/2015 repentation, what you have made come? What prayer you made?
My lord, here twofold prayer are there, my lord. One is, my lord, that direct payment, and another is, my lord, re-engagement, my lord, us for executing that midday meal program. Twofold prayer are there before the concerned DM, my lord. That was directed to be considered by the DM, my lord.
So that your wages or remuneration for doing work up to June 2014, they have not paid it as yet.
Yes, my lord. That is there, my lord. And another thing, my lord, re-engagement.
Re-engagement, what can be stated? How court can?
That is there, my lord. The last line, my lord, at page 51, my lord.
From all documents, it is clear that all four groups have been functioning as in the school some purpose. In view of above, block steering is directed to observe work of each self-help group very closely and keep them engage or terminate on the basis of periodical evaluation of their performance in accordance to your authority.
Yes, my lord. Their work, my lord, under scrutiny, my lord. That was decided by the concerned.
So what wrong with this order?
My lord,
Only omission to consider their payment up to June 25.
And also our engagement. That is also
The
there.
engagement they have stated. How court can do it? Yes, while they keep them engaged or terminate on the basis of their periodical information of power.
That is in.
Four who help self-help group are working.
But they are
Now-
working, my lord. We were working under them, my lord. Because we attached to four groups, my lord. They are working, my lord. So we should be given preference. That is our prayer.
For doing your past work.
Yes.
Why is the rule you show that you have done past work, so they are bound to give preference to you, and they are bound to continue to engage you?
My lord. My lord, there is one guideline, my lord. My lord will find it from page number 39 onwards, my lord. This is revised rate of honorarium.
You come to a particular relevant portion. You come to page 39.
39, my lord, that is the guiding principle, my lord.
Revised rate.
This is with regard to the revised rate, my lord. As a matter of right, my lord, perhaps, my lord, I won't be able to show to your lordship, my lord.
So I am to set aside the order of the district magistrate.
That part I will consider.
Order of the district.
For my non-payment of our work done, my lord, that payment should be made to us, my lord. That part should be considered by the concerned DM.
So you made an repentation. DM will consider.
My lord, give us that liberty, my lord. We will make representation to that effect, my lord.
The present petition has been preferred, challenging Yes. Affidavit's complete.
Yes, Lordship.
Oh.
A petitioner before your lordship is a dismissed employee from the CRPF.
Disciplinary proceeding. You have been removed.
I mean,
Yes.
dismissed, my lord.
Oh.
Against the order of removal, my lord, there was an appeal preferred, appeal dismissed, review, my lord, review dismissed, a mercy petition was filed, that also dismissed. Now I am before your lordship, my lord.
What is the charge?
Yes, my lord. By the petitioner, my lord, was inducted in the force, or in the respondent force in the year 2004. But there is a standing order of the CRPF which mandates.
Oh, fake certificate.
It's a,
Caste.
no, the educational certificates of class 10 examination.
The school certificate.
And may I just indicate the facts before your lordship. By the CRPF, there is a standing order which mandates that once the employee has been inducted into the force after a certain period of time, but there would be a revalidation of the certificates that he has been given at the time of his entry, my lord. Now at this point, my lord, this point of re-verification, my lord, it was found that, my lord, the class 10 mark sheets, my lord, that has been given by the petitioner, mark sheet as well as, my lord, the pass certificate, were, my lord, found to be fake in terms of the communication that was given by the board. But may I just show to your lordship, my lord, the certificates. Your lordship may kindly come to page 21.
Yes.
And this is the mark sheet. Your lordship may find, my lord, at the bottom, my lord, the date, that is, my lord, 9th of September 1999. Your lordship would also find, my lord, certain lines written in Hindi, certain endorsement.
Yes.
And the reason was, my lord, that, my lord, when these marks were published, initially, my lord, the marks were withheld. The petitioner's marks, my lord, were withheld, along with many others. That compelled, my lord, the petitioner, along with the other persons, my lord, to approach, my lord, the Honorable High Court at Allahabad. Your lordship, my lord, would find at page 23, it's a Hindi copy, but the translated copy is at next page.
Yes.
But may I place, my lord, that translation copy? Page 24, my lord.
24, yes.
And this is a letter which was issued, my lord, from the Regional Secretary, Intermediate Education Board, Regional Office, Uttar Pradesh, to, my lord, Principal RDA Higher Secondary School, where, my lord, the petitioner was a student, my lord. So, result for year 1996, high school stroke intermediate exams of students appeared therein, whose details are as under is withheld as WA or WB, which may please be declared immediately. And I'm just giving the next paragraph, the subsequent paragraph. As per direction of the Honorable High Court, mark sheet of examinees be immediately be given. Due to non-receipt of mark sheet, the examinees take assistance of court by which unwanted difficulties are created. It is therefore requested that such arrangement may be made so that the mark sheet are received by the examinees within 3 days. Please take acknowledgement of mark sheet from the examinees. Please ensure that the result of concerned examinee is not withheld in any other list. If the result of the aforesaid list is being declared and its result is withheld in any other list, then the mark sheet should not be given. Now, the details of the examinees, your lordship would find, my lord, the second line. Your lordship would find, my lord.
Yes.
There's a roll number that is 1389180. And then subsequent to that, 137. So it will be 1389, 137, and that is the roll number of the petitioner. Your lordship may corroborate.
137.
Yes, my lord.
And what is 1389180?
Number. The initial numbers are same. The last 3 numbers are different.
Okay. Yes.
If your lordship kindly comes to page 21, my lord. Again, my lord. At the very top, your lordship would see, my lord, the roll number, that is 1389137.
1389, 137, yes. Yes.
Now, the next paragraph is very crucial, my lord. If provisional mark sheet is given earlier to the concerned examinee, then the same may be taken back in original and destroy the same. Action taken be intimated to the undersigned to registered post as per order in writ number such and such and special appeal number such and such, as also under the order dated such and such. The withheld provisional mark sheet is issued which be admitted under the decision of special appeal. But the case of the petitioner is that after he had approached the Honorable High Court at Allahabad, there was a direction for issuance of the mark sheets, and along with the mark sheet, the pass certificate was also issued. Now, during the re-verification period, the board says that no, we haven't issued any mark sheet or any pass certificate to this concerned person, and the documents that has been appended by the petitioner at the time of the entry into the force are fake. Your lordship may kindly comes, my lord. Page 25 is on a standing order, my lord.
Yes.
Verification of date of birth as well as educational certificate.
From
page 25, my lord, annexure P2.
25, yes. 25, which
and this is the standing order in terms of which, my lord, the mark sheets as well as the other certificates of the
was sent to the department for verification, to the board
yes.
for re-verification. Yes. The board has said no such certificate has been issued.
Yes. The lordship kindly comes to my lord, page 32.
Yes.
And this is the initiation, my lord, wherefrom, my lord, the board for the first time communicates to the, my lord, the CRPF or the respondent, my lord, that this is the fact. May I place that letter? But 31 is the, my lord, page 30 is the original letter, but 32 is the translated copy, my lord. It's a letter which is dated on the 13th of October 2010 from the regional secretary, my lord, to the office commandant, 129 battalion, my lord.
Yes, yes.
So kindly take note of your letter number such and such. High school examination roll number such and such. Well, this is not, my lord, of the petitioner. The lordship kindly skips, my lord, the next comes to the next page, my lord. Because there were 3 persons, my lord, against whom, my lord, there was allegations. But page 33 would be, my lord, the Sanjay Singh, that is the petitioner before your lordship. Kindly take note of your letter number such and such. When you said letter, it is mentioned that in the high school exam year 1996, roll number such and such, Sanjay Singh, son of Sri Prem Singh, his results were withheld in category WB. Xerox copy of the qualification certificate has been sent along with your letter. However, no such certificate in favor of Sanjay Singh has issued by the Education Board on that specified day. My lordship kindly comes to the next page.
34.
34.
Yes.
And this is the mark sheet that the board claims was issued to the petitioner. Now, kindly see, my lord, the date at the very bottom of the page.
15th January 2011. 2011, yes.
The lordship kindly appreciate a person who approaches an high court and an order is passed saying that the mark sheets be issued. But if I take into consideration that the statement of the respondent are correct, so an order which was passed in 99, so the board says that the order of 99 has been complied in the year 2011. But this is preposterous, my lord, absurd, my lord, can't be. Now, if your lordship kindly compare this page 34, which page, my lord, 21. I'm sorry.
Yes.
Your lordship would see, my lord, there is no difference of any marks. Marks are all the same. In fact, my lord, even, my lord, the serial number is different. Why? Because this mark sheet, which is at page 21, was a provisional mark sheet, which was given in terms of the order passed by the Honorable High Court at Allahabad.
21.
21. This mark sheet I got from the school.
Now the word provisional has been written.
Yes, your lordship would find, my lord, at page 21.
Eh.
But there is a writing in Hindi, my lord, and it says, my lord, माननीय उच्च रीट नंबर सच एंड सच अपील के आदेश के अनुसार this says whether in terms of the order passed by the Honorable High Court at Allahabad, this certificate is being issued, my lord. This is the mark sheet, and the next page is the certificate.
Yes.
Again, my lord, kindly see the date.
1996.
And that is the year in which I appeared in the examination. Your lordship will tally this 35 with page 22.
Yes.
This was also a provisional pass certificate which was issued to me. And this is the final certificate that was issued.
Yes.
And one more point that I would like to point out before your lordship is that this is plus 10 document, but I have completed plus 12 education also from this very this board. But the board never raised any question, my lord.
Huh?
This board, I have completed my plus 12 studies also from this very board. On the strength of this document, they never raise any objection, my lord. Now, my kindly comes, my lord, to the page 37, my lord. It is a type copy of page 36, where my lord, the regional secretary of the Intermediate Education Board Regional Office, Uttar Pradesh, Meerut, my lord, makes a communication to the principal of the school from where the petitioner had, my lord, appeared in the examination, saying that in the result sheet sent by this office, mention opposite following roll number by using W0 or WB struck off, referring this letter and put your signatures. As per the directions of the Honorable High Court, mark sheet of examinees be immediately be given. Due to non-receipt of mark sheet, the examinees take assistance of the court and such and such. So,
it was produced before the inquiry officer.
Yes.
Any person from the board deposed.
But person from the board deposed, the communications were there, but no person from the school was called for. Because my contention is that I got this certificate from the school, and the school all along has said that yes, we have issued this certificate to this concerned person, and this point was taken. But more interestingly, my lord, when the
by filing any application, you express your intention before the inquiry officer that the representative of school is required to be examined.
But this is my deposition, man. I will show to your lordship. I've made this point.
You have to make application.
Yes, in my appeal, I have taken this point. These specific points are there. I will show to your lordship, my lord. Now, more interestingly, my lord, when the initial charges were issued, they said that both my mark sheet as well as my pass certificate are forged or fake. And by the time I come to the appeal, they say, no, your mark sheet is genuine. We concede to that. But your pass certificate, we have some doubts on that. So they on their own have shifted the goal post for me to satisfy their claim, my lord. Your lordship kindly comes, my lord, at page 40.
Four zero,
my lord.
Yes.
But the board says, my lord, that no issue, that no such things were issued to the petitioner because his result was withheld. And 41, my lord, on the basis of the decision taken by the Intermediate Board, UP Allahabad Exam Committee dated 5th of January 2011, The result of the high school exam 1996, roll number 1389137, which was withheld in the list WB, was declared on 15th of January 2011. Your lordship would also find that when the communication at page 40 does not take into its ambit the orders passed before in the High Court of Allahabad. At page 42, your lordship would.
No, you used the certificate at the time of your entry.
Yes.
Which certificate? Page 35?
No, 21, 22.
21, 22. 21 your mark sheet?
Yes.
22 is the certificate. Its number is a certificate number. Take us to certificate number.
Yes. Your lordship would find the certificate number at the very top, my lord. Cramang, at the very top, my lord.
040840920.
Your lordship is that?
So where from here, bottom portion, 5-8.
Your lordship is that, my lord?
22, page 22, left side bottom.
Certificate number.
Bottom number, certificate number 0840920. You use this.
Yes.
You annex this with your application.
Yes.
This certificate, page 22. Now you come to page 40. On the basis of this information, certificate number is different, was declared forged document. 08409 2016.
No, my dear, this is a typographical error because if your lordship.
So, here 16 was there.
Okay.
So they are saying that certificate number 35 is correct.
Yes.
But 22 is not correct. It is forged.
But my contention is that kindly comes to page 42. That is the article.
42.
Yes, articles of charge.
No, whether the Allahabad High Court directed to issue mark sheet or mark sheet and certificate.
Mark sheet as well as the certificates were also being issued along with the mark sheets.
42.
Yes. Now this is the copy of the charge. Now the type copy your lordship would find. It starts from page 46.
Your stand is this is the certificate which was issued by the board in compliance with the order of the.
And to the school. To the school. To the concerned school where I was a student.
This certificate was issued through the school.
Yes.
So what prevented you from taking anyone as your defense witness from the school authority?
Yes, but But if your lordship kindly sees my deposition and everything, but I have appended a letter of the principal of the school who says that yes, we have issued this. And when they have not been called for any type of a cross-examination by the disciplinary authority, my lord.
Principal issued
Yes.
certificate, that this certificate was issued from the school. Okay. Take me to that certificate issued by the principal of the school. Page?
I'm just pressing my lord.
No, page 112. The above letter does not specifically make any mention of the certificate number such and such which was reported to have been issued in name of the petitioner through school.
Yes, my lord.
Come to page 112.
Yes, my lord.
A special DG Central Zone, you come to para 8. Last line.
Yes. But kindly read the entire paragraph, my lord. And whereas, even after issuing reminder, wide letter to such and such, insisting for copy of apostate copy and letter, and finally the petitioner made available only the copy of the letter dated 19/7/2013, written by the principal RDA Higher Secondary School, such and such, in the name of this office. The above letter does not specifically make any mention of the certificate number, which was reported to have been issued in the name of the petitioner to the school. But there is no controversy, there is no, there is apparently no contradiction to the point that the school all along has been of this opinion that they had issued the certificates.
How it has been proved?
Yes. And kindly see the charges for the moment at page 47. And the initial charge.
Oh, your charge would be that you entered into the service by producing fake certificate, not forget about the mark sheet. Now, question is the certificate, which number such and such, 0840920. Maybe 16 would be inserted. So you produce the fake certificate. It was the allegation. You are claiming that in compliance with the order of the Allahabad High Court, this mark sheet and certificate were issued in your favor through the school. So only two authority can say, one board, whether such certificate was issued by them or not, and another is school authority, whether this certificate was issued to you through them or not. If the prosecution omitted, maybe for any reason, to produce them as witness in inquiry proceedings, you could have produced, made an application that I want to produce them as my defense witness.
Now, my lord, kindly appreciate, but the source of the documents, that is, but the mark sheet as well as my lord, this pass certificate is the same, my lord. So, if today the initiation of the charge was that both of my documents are fake, then at a subsequent stage, when they himself accede to the point that my lord, the mark sheet is genuine, we don't have any issue to that, but the certificate is fake, and that is an apparent contradiction to the charges that has been framed against me, my lord.
How?
And kindly see, my lord. Assume-
Suppose in an allegation, criminal allegation, it was alleged that this person has committed theft of some amount of money and gold ornament. Now subsequently it is came, no, he has not committed theft of any money, only gold ornament. Whether entire allegation will go?
And that has to be proved, my lord. And where is the document, my lord, or the evidence which says, my lord?
Initially, they claimed that you produced both fake certificate, both mark sheet and certificate. Later on, they came, no, mark sheet is genuine, mark sheet was issued, but that certificate was not issued.
But if your lordship,
It is fake.
but
So
if you-
whether entire allegation will go?
yes, if your lordship peruses the communication from the board, they all along have been saying that both the mark sheet and this certificate is forged. It's only for the first time because what happened? The petitioner, my lord, well, kindly appreciate, my lord, petitioner approached, my lord, the High Court in the year 1999. And at that point of time, my lord, but kindly, my lord.
Oh,
yes.
you are not answering on the pattern point.
Kindly, my lord, appreciate.
Okay, who deposed before the inquiry officer? Yes. Who deposed? Anyone from the school authority?
No.
Or anyone from the board deposed?
There was a communication of the board,
Huh.
but nobody came from the board, man. That is too many instruction. There was no deposition from the board. Only two communication
But
letters.
the communication was accepted as evidence.
Yes, by
You
the-
did not raise any objection.
Yes, I have raised objection, my lord.
So that you raised objection.
Yes, I will.
That without examining the person concerned from the board, you cannot take this as evidence. So,
But kindly take up the charge first, man, at page 47.
charge, page
47, my lord.
Oh, okay. I am saying charge, maybe the entry in the service using fake certificate. That would be okay. That would be, except this, nothing can further
Page
charge.
48, my lord. Page 48 is something, my lord. That,
Have you annexed the minute of proceedings?
yes, my lord. Whatever.
Page 48. Page 48. Yes, 48.
This is, my lord, the details description of the misconduct in support of the charges claimed against source number such and such. But may I place this document, my lord?
Yes. Enter.
I should be, my lord, because
Enter.
I would be, my lord, reliance on this, my lord.
Okay.
Or your lordship may skip over, my lord, and comes to, my lord, there is a paragraph starting, my lord, as per board record, high school exam 1996, roll number such and such was
As per board. Paragraph 2 or 3
that is, my lord, not
or last paragraph.
the first one, my lord.
First part. Yes.
The middle portion, my lord, as per board record, high school exam 1996, roll number such and such, examinee Sanjay Singh, Prem Singh, result withheld under category. It's in bold, my lord.
A force number, read first paragraph, start with force number, such and such.
A little down, my lord.
And therefore, as per rule,
No, my lord, there is a line, my lord, at this, my lord.
in order to get verified.
After, my lord. The lordship has page 48, my lord.
48, yes.
Then there's a line starting with inverted comma, my lord, at the middle portion. In bold, my lord, your lordship would find.
Yes, as per board, yes, as per board. As per board record, high school examination 1996, roll number, examine, result was held under category. Therefore, in the circumstances, yes, read.
Therefore, in the circumstances, due to non-verification of the certificate of the employee by the board, the office, while it dated as such and such, had directed the concerned employee to submit his clarification. In response of which, the employee has submitted high school certificate 01243 in 1995. I am not giving details. And high school mark sheet number such and such in this office, in which it is stated that the employee had passed the high school examination in second division. Therefore, while annexing the copies of this wide related number such and such, request was made again for re-verification through special messenger to regional office Meerut. In reply of the same, Madhyamik Shikha Parishad Uttar Pradesh, regional office Meerut, the concerned Shiksha board wide their verification report number such and such, dated such and such, high school year when roll numbers stated that as per record of the board, the result of the above roll number was retail under category such and such. It can also be found that student Sanjay Singh certificate has been issued by the board based upon which the same certificate number 0840920 was carried to the fore. Now, as per the decision of the examination committee of the Uttar Pradesh Madhyamik Shiksha Parishad, Allahabad, dated 5th of January 2011, the result of the high school examination year 1996 has been declared from ND category on 15/1/2011. Therefore, the mark sheet 9797 and serial number 01234 has been issued by the board. The certificate number 840920 was not issued by the board. Therefore, the certificate number such and such submitted by the employee was not issued by the office of the board. That is, it is forged. But nowhere in this report, my lord, in this communication, the board says that there was an order of the Honorable High Court. We had directed the school authorities to issue the certificates. And not as whisper of the order of the High Court. They say that the mark sheet of this petitioner was only issued after they got this letter of the CRPF regarding the verification in 2011. And this same authority, my lord, from where I have graduated, but I have appeared from a class 2 examination, never raised any objection. This is the same document, my lord, on the strength of which I have appeared in my class 2 examination. Now, my kindly comes to my lord. Report of the inquiry officer at page 56.
Page 54.
56, my.
56, yes. Yes.
And the second item is ambit of charges. Item 1, that force number such and such, while working as above with CRPF under section 11 subsection 1 of the CRPF Act 1949, has been found involved in misconduct that at the time of initial appointment submitted forged certificate stroke mark sheet, not being eligible for the said post. On verification of those certificate mark sheet, the Secretary Madhyamik Shikha Board Regional Office Meerut, why his verification reported at such and such and re-verification reported at such and such, has informed that as per the record of the council, the result has been stopped under WB. Therefore, the educational qualification certificate which was submitted by the above said forced number at the time of recruitment is a forged document which is punishable offence under CRPF regulation 1955 rule 27. But this is the finding of the inquiry officer. At the subsequent stage, this very authority at the appellate stage says, no, I am accepting your mark sheet, but not accepting your certificate. But there is no further communication from the board, which says, yes, today we are accepting the mark sheet. His mark sheet is genuine, but his certificate is forged. There is no such communication, my lord. The board communication was, we have never issued any mark sheet nor any certificate to him prior to 2011.
In the mark sheet, there was an endorsement that
Yes.
it is issued in compliance with the order of Allahabad High Court. In the certificate, there is no such endorsement.
But your lordship would also find that the number in the certificate differs from the number which is given, so-called the purported final mark sheet. But supposedly, if I had obtained the forged document, but I would have understood it's a forged document if the serial number matches with one of the serial number that was been indicated in the final mark sheet. but the serial number differs because that was a provisional certificate, not the final certificate. As it is in the case of the mark sheet, the serial number differs, my lord.
There must be some indication that it is provisional or such and such. Certificate, there is no such indication
no such
also that it
indication.
is.
I have gone through, my lord, there is no such indication.
So here is the application that you wanted to examine
I'll show it.
any authority from the school or any authority from the board. Who are the witnesses?
Your lordship would find
Management
that-
witness or
Your lordship would find at page 49.
list of document, list of proposed witness. Commandant such and such, company writer, other witnesses. How many witnesses examined? Were examined?
No witnesses was called, my lord.
Huh?
No witnesses were called. Only
No?
witnesses were called. Only, my
No,
lord.
no.
I may be wrong, my lord. My learned senior friend may correct me, my lord. Yeah, this is on instruction I am being.
After considering the statement of department witness and carefully considering the evidence brought by them on record, unless you admit your guilt, there must be, they must produce their evidence and such and such.
So that is my case. They haven't applied their mind. They've only acted upon the communication of a board.
Nowhere, no application did you express your intention to examine any representative of the school or any representative of the board.
Your lordship kindly come to my appeal petition, my lord, at page 66, my lord.
Page 56.
No, my lord. My appeal petition, your lordship would find at page 69.
Oh, forget about the appeal. Whether by filing any application before the inquiry officer, you expressed your intention to examine, to call for and to examine any representative of the school to ascertain the fact whether this certificate was issued through the school or not.
I might submit to, based of my knowledge, my lord, the proceedings which is done before the CRPF authority, my lord, but I don't think that I have a choice to file any application. I can say that I can opt for this person who can come as my witness. There is no proceeding offer, there is no
They will not give any defense witness.
defense witness, they will
Huh?
give me.
He would ask whether he wanted to.
So what can be done?
I come to page 66, my lord.
Basically, it is challenging or difficult for anyone to prove any negative fact. Okay, I have not given ₹100 to Mr. Such and such. I cannot prove. You have to prove yes.
Your lordship, I
Yeah.
come to page 66, my lord.
Yes, he was given, and this is that note, or this is that letter.
Your lordship, kindly come to
I
page-
cannot say that that I shall be able to prove negative fact. It is challenging or difficult for any person to prove any negative fact. Now, in that circumstance, the person who has asserted certain fact, yes, this letter was issued or this was issued by this authority, then this person is to prove, and he is to make an application before that call for the record, call for the register.
Your Lordship may kindly.
Every certificate or letter from any department issued under a number, memo number, date. Okay? So you could have asked, memo number, date, there must be some register in every authority that on that date, certain memo was issued. Then the register will be taken out. Then on that date, it would be verified whether any such memo was issued on that date or not. That would be the memo number 51. Thereafter 50, 51, 52, 53, 58. Whether 51 number memo dated 7th July 2016 was at all issued or not.
And if that be so, my lord,
Everything will come out.
that this same principle applies to board also, my lord. But kindly appreciate, my lord. But kindly come to page 66, my lord. Kindly comes, my lord. I am no matter what is troubling your lordship, that the mark sheet there is an endorsement, in the certificate there is no such endorsement. Had there been any endorsement, the petitioner would have, my lord, in a better, my lord, footing, my lord. And kindly appreciate that petitioner applied for the post of a constable. This is not a fact that petitioner, my lord, applied for the post of a post which requires, my lord, a certain degree of, my lord.
If you want, if you find that you are not sufficient to defend yourself, you could have made an application, I engage my representative.
I have taken those points, my lord. I have taken those points.
Where is that?
Yes, I have shown, my lord. I'll show, my lord.
That application, where is that application? That from the school representative along with the register, please call for. It is my application.
And kindly comes to page 70, my lord.
Page 70.
Yes. It starts from page 69, my lord.
Yes.
Comes to
11, come to 11. Person,
But paragraph 4 and paragraph 5.
Yes.
That consequent to the directions of the Honorable High Court, the respondent regional secretary such and such had directed the principal RDA Higher Secondary School, Sarai Chabila, so to declare the results of the students appeared, issue mark sheet to the concerned students immediately within 3 days and obtain an in case provisional mark sheet by issued. Then pursuant to the above directions, the regional in compliance of such and such. But I had placed this fact, but at the moment I placed this fact before the authority, but it's the incumbent upon the authority to call for the records from the school department, from the concerned school, my lord. But I have left this school in way back in the year 1999. But this proceedings is in 2011. But kindly appreciate that fact also. The gap of nearly a decade, more than a decade, my lord.
Oh, most probably I am not clear. Suppose an authority has sent a board, you kindly let me know whether this certificate was issued by the board or not. Board, by its communication, stated that no such certificate was issued. That letter has been proved. That letter has been accepted as evidence.
It has not been proven. Whatever contention of the board, I cannot, because I don't know the averments of the board unless I am being aware of it.
Any communication from the board has been accepted as evidence?
That is the contention of the respondent authorities. That this is a communication from the board.
Maybe that has been accepted as evidence without examining the person concerned from the board. You have not raised any objection. You could have raised objection that without examining the person concerned, don't take as evidence.
But kindly comes to paragraph 7, my lord, at page 71. Paragraph 6 and paragraph 7, my lord.
Yes.
I'm sorry. The disciplinary authority in the impugn order dated such and such in para 5 doubts the mark sheet dated such and such issued by the principal without doubting the authenticity of the letter dated 8 September 99 of the Regional Secretary, Secondary Education Board, Meerut, addressed to the principal, based on which the principal had issued the revised mark sheet dated such and such. Therefore, the conclusion of the DA commandant to award disproportionate and shocking punishment of removal from service is based on conjectures and surmises, and is based on mere suspicion in the absence of any concrete evidence whatsoever. And the next paragraph, my lord, it is a settled principle of law that before awarding any punishment, all material facts available must be taken into account, considered, and then should be arrive at a conclusion. In the event the DA differs on the DA can arrive at a conclusion to award major penalty of removal from service based merely on suspicion and doubts. And the language may be not be accurate, but this appeal the petitioner had made objection, my lord.
Yes, no, there is no. You have given 15 days time to bringing on record the supporting document in his favor. Page 61.
These the petitioner, there was some lacuna on his part, because all these orders and everything was not available with him, but these
Actually, a read court will not enter whether the decision is proper or not. Okay, whether before taking decision there was any illegality in decision making process or not. It is amenable to the jurisdiction normally, and court can enter into the decision to examine its justification only on the ground whether it is based on no evidence.
on
the
this
perverse.
point,
It is
on this
perverse.
point, my lord, there
Unless these two things are
I
satisfied,
clarify your lordship, my lord.
court cannot
I
enter.
clarify your lordship, my lord. And what is the charge, my lord? Forgery. Forgery, my lord, is we say is corruption, my lord. It's a way of corruption. And our honorable division bench, my lord, kindly takes up this judgment, my lord.
Yes.
Well, it's reported in 2012, volume 5, CHN 476. Your lordship kindly comes to paragraph 19, my lord. In the case of Union of India versus Gyanchand Chattar, reported in 2009-12 SCC 78, the Supreme Court observed that while dealing with the serious charge of corruption, an inquiry officer should consider whether the charge is proved to the hilt, as it attracts both civil and criminal consequences upon the employee concerned. Such a charge cannot be proved merely on probabilities, and considering the gravity of the charge of a quasi-criminal nature, it must be proved beyond any shadow of doubt and to the hilt. But in this case, my lord, these two principles has not been, my lord, being satisfied. It's only on suspicion and doubts when the order has been passed. That there is an order communication from the board. It says no, there was no issuance of, my lord, the mark sheet. No officer from the board was witnessed, was examined. But I made a specific plea. The school authorities could have been called. They were never called. So only on one letter, my lord, which also does not, my lord, take into consideration, my lord, the order of the Honorable High Court of Allahabad. If I today, my lord, we take, my lord, the contention of the board, so my lord, an order of High Court is being supposedly, my lord, complied after, my lord, a gap of 12 years. An order passed in 1999 is being complied with in the year 2011 once when they have got a verification letter from the CRPF. The Lordship will also appreciate that position also.
Okay. Next, any other judgment?
But I say, my lord, and assuming, my lord, there was some lacuna on the part of the petitioner, my lord, what happened, my lord, when the matter was taken up by, my lord, the earlier bench, my lord, what failed from his lordship, that, my lord, the punishment that has been imposed on the petitioner may be disproportionate. But because of the fact that subsequently there was a genuineness of a document was, my lord, being proved by the authority itself. So, my lord, the punishment inflicted on the petitioner was not proportionate to the, my lord, the misconduct, my lord, and that if it could be reduced, my lord. And on that proposition, my lord, if I may place, my lord, is, my lord, 2009, my lord, volume 3, Supreme Court cases, 1997, my lord. Sir, ma'am, 2009, volume 3, 97. And may I place? Right, paragraph 15 is the relevant paragraph, my lord.
You have given two copies.
I'm sorry.
Para
15, my lord, would be one of the appropriate paragraph. Madam.
disproportionate.
Yes. Now, if your lordship comes to my paragraph 15, my lord, the doctrine of proportionality in a given case may be invoked by the superior court in exercise of its jurisdiction on Article 226 of the Constitution of India. It was so held in Ranjit Thakur versus Union of India that judicial review, generally speaking, is not directed against a decision, but is directed against the decision-making process. The question of the choice and quantum of punishment is within the jurisdiction and discretion of the court-martial, but the sentence has to suit the offense and the offender. It should not be vindictive or unduly harsh. It should not be so disproportionate to the offense as to shock the conscience and amount in itself to conclusive evidence of bias. The doctrine of proportionality as a part of the concept of judicial review would ensure that even on an aspect which is otherwise within the exclusive province of the court-martial, if the decision of the court, even as to sentence, is an outrageous defiance of logic, then the sentence would not be immune from correction. Irrationality and perversity are recognized ground of judicial review. But I have certain other judgments, my lord. If your lordship only can give me one day moment, I can come with those.
No, what are judgment? Same. Opposition is same. Don't require to multiply.
Now, this is my case, my lord. That, my lord, the documents that I had submitted, my lord, were genuine, my lord. But somehow, my lord, the board, my lord, for reasons based, my lord, they are party to this petition, my lord, but they have never appeared in, they have entered, never, my lord, they have appeared in this matter. But for reasons based known to them, my lord, they have made this communication, my lord. But I never got a chance to witness them, my lord. I had made a plea that I have got this certificate from the school, but there has been a consistent view, my lord. There has no been, it's not a fact that I have changed my position from time to time. There has been a consistent view. But the school has also, my lord, written, maybe the later, my lord, may not be specific, my lord, but the school never said that, no, we have not issued any certificate to this person. The school has said, but kindly appreciate, my lord, the board says that your lordship, my lord, had initially, my lord, pointed me to page 112, my lord. So kindly come to 112, my lord, once, my lord. Paragraph 8, my lord, kindly see, my lord.
Yes, I have seen.
And
That-
if we-
That above letter does not particularly make any mention. Yes, I have seen.
now, my lord, kindly appreciate, my lord. I left the school, my lord, in the year 1999. So, my lord, the authority here, my lord, is not disputing to the fact that there is a letter from the school which says that they have issued a certificate to me. What is their contention is that it not specific, that this letter with this certificate with this number was issued. But they could have, my lord, endeavored, my lord, to ascertain from that authority.
Okay.
But that has not been done. This is
Lordship has seen that the question is the certificate that he had placed at the time of recruitment. That is the certificate in question. And it's our duty to verify whether that certificate is genuine or not. So the compass is very narrow. What he has placed at the time of recruitment with his forms, that is what is to be verified by us. We verified it, and not once. We have done it several times. We started the verification process I mean, it has gone for about 5 years. That's why this entire disciplinary proceeding took such a long time. And on each occasion, the board has said it has not been issued by them. Lordship, and this certificate, Lordship sees Madhyamik Shiksha Parishad, Uttar Pradesh. Lordship comes to page 22. The certificate that he had used at the time of entry into service. Madhyamik Shiksha Parishad, Board of High School, and so it was issued. This certificate has to be issued by the board. Now the board says we did not issue. That is how the trouble started. Whatever has come in at a later point of time is something different. But this certificate, which was given to the authorities, Lordship, and the recruitment process that started in 2000, I mean, in 2003, if I'm subject to correction, this is the certificate relied upon. And this is the certificate where the board has, I shall place the affidavits, Lordship, it's not once. Because it is our instructions, if you don't get a letter, you send a person to the board. And we have done that repeatedly. In fact, my learned friend had given when he said that the mark sheets and certificates, it was the letter dated 2010, again we went to the board. So the issuing authority, if their consistent stand is, we did not issue, then, Lordship, it is very difficult for us to rake what has happened. The fact remains that the entry point, the certificate relied upon, is a fake document. The authority issuing the document said it was not issued by us. And that has given rise to the entire proceeding. Till he was given, as your Lordships have correctly pointed out, there was he could not produce any other document. But this certificate, Lordship, there has been the issuing authority, that is how we decide whether it is fake or not. When the issuing authority says, I have not done it, then it is a manufactured document, it's a fake document, and a document that is used. It's not that we are giving a document that he has not used. It's not been manufactured by us to it as a vindictive measure. This document was relied upon by my learned friend's client at the point of entry into service. We have, Lordship, I have the affidavit in opposition, Lordship will see. It has shown that how many times we have gone. It's been this entire process, it started from 2008, we started the process of verification. The verification process continued till 2011. Repeatedly we have gone, and repeatedly we have come back from the board with the same reply, that the document is fake. In that circumstances, our hands are also tied. Unless there was some other evidence which opportunity was given to him, he had also, been given the opportunity to produce defense witnesses, but at no point of time was that. So ultimately, what boils down to is an issue of a usage of a fake certificate at the time of entry point, and that causes serious repercussions in an armed force, in a semi-armed force, where they have to be truthful. The form says that you can lose, it can result in loss of service at any point of time if the documents are not genuine. And this is what has happened in this case, Lordship. Therefore, Lordship, if I...
He is saying that the punishment is disproportionate.
Lordship, according to the form, Lordship, according to the application form says, should there be any, there the punishment does not become disproportionate because at the entry point, he has used a certificate which was not issued. Because Lordship even sees all the other certificates issued are from a later period, which he has not used. And therefore, at the entry point, the punishment is you are liable to lose. The appointment is liable to be cancelled. So that is why it is, in my humble submission, it is not that during the course of duty something happens and there the punishment can shock the conscience of the court. But here in my humble submission, Lordship, the punishment is the consequence that he knew would come. I shall, on the next year...
Actually, he has not taken any advantage, extra advantage or anything, extra benefit in there. He admittedly, he passed Madhyamik.
He has passed.
Marksheet will indicate the same. But the certificate which was produced is a fraud. Yes.
It's fraud. It's a fake document. That is what I'm saying. It boils down to usage of a fake document.
So punishment is proportionate according to you.
Because, Lordship, that is the requirement of when at the entry point of service, one has to, that warning is given to each candidate. Thereafter, Lordship, it's true in the previous coordinate bench had raised this issue, Lordship, but this is at the entry point. Lordship, if your Lordship desires, I'll get the forms, whatever. This is a warning that is given to each candidate that you must, what it entails using a wrong declaration, a forged document, it entails loss of service.
Yes.
Only one reply, my lord. My learned senior friend has said, my lord, that there were several, my lord, attempts or several, my lord, they had, my lord, ventured into, my lord, numerous times to ascertain, my lord, the genuineness of the document. And if that be so, but what stopped them from going to the school authorities for once?
That is not done.
But they knew from the school, my lord, this is my consistent, my lord, my submission that I have got this document from the school. But they could have went to the school also, my lord. But what stopped them from, my lord, only approaching the board and not the school? But there is not a single communication which says that the authority, my lord, the CRPF does not say to the board as to why have you suppressed the orders of the court when initially when you had sent the communication that no, this was not, all these mark sheet and certificates were forged. Why on a subsequent stage have you now deviated from your stand?
Again, you are repeating. Again, same thing.
Because that is what this stand of the respondent also
did. Suppose it is the trial, it is a rule for trial. Actually, disciplinary proceedings is also quasi-criminal proceedings. If suppose prosecution intentionally omits anyone to examine, who may be material witnesses, one who could have,
in a case of corruption, it vitiates the entire process, my lord.
Who could have unfolded the story in a better manner. Prosecution for any intention he has. Now, when the defense will get a chance to produce his evidence, he by filing application says, I want to examine it.
I've raised those points, but it's not a fact that
Because in every trial or where evidence is taken before arriving at a conclusion, then both parties are given opportunity to produce their respective evidence. Okay, oral evidence, documentary evidence, material, three types of evidence. Yes, you have produced, you can use your oral evidence.
accept.
Then immediately after completion of one side, prosecution who generally bring the allegation, then the person who against whom allegation has been brought is be given a opportunity. Do you want to adduce any evidence? So give us your list. If they omit, you should have write it. Bring the person concerned. This certificate number 51 dated such and such was issued from the school. Or bring the person concerned from board. The certificate. And using a false certificate as a genuine is a offense.
But this is a document,
461, 471 of earlier IPC.
Your Lordship also will take note, madam, that this is a document on the strength of which I have completed my class 12 studies from this very board itself.
Not that document.
Okay, yeah. Okay, yeah. Everything will be checked again. Acha, had the learned advocate opinion for the respective parties, judgment reserved.
I'm grateful.
My application, by the way.
Mr. Vikasranjan Bhattacharya and Mr. Lakshminarayan Gupta, also the LK Gupta, my lord, senior advocate, both are typical, my lord. Mr. Gupta in arguing code number 36, my lord. Mr. Bhattacharya is out of session. My lord, one reason I am praying for not this week, not today, or according to your confidence, my lord.
My lord, only thing I am telling your lordship may kindly recollect that on the last occasion, my learned senior friend Mr. Bhattacharya argued on the point of constructive res judicata. Now, my lord, that was by referring to the prayer made in the earlier writ petition. My lord, that is, my lord, I should say, Ordho Sotto. Ordho Sotto. Or Sottama Hato iti goja like that. Why I am telling you, lordship, for that purpose, my lord, I have, my lord, formed a supplementary affidavit annexing the writ petition of that earlier writ petition. Nothing else.
Oh.
I could have.
I mean, sub copy.
Copy, sir. Only thing, my lord, I am praying leave or lordship so that I can file the application, supplementary affidavit.
My lord, kindly give me leave to file the affidavit on behalf of.
Writ petition only.
Only writ petition.
Writ petition. Only writ petition.
The supplementary affidavit filed on behalf of the petitioner is taken on record. Because that's leaves the matter for. Item number? Hey, Baba. 26.
That I am for the private
For the state respondent led by Mr. Joyanto Soman.
Huh? Take the mic.
Matters relating to unauthorized and illegal construction made by the private respondent without any taking prior permissions of the Panchayat authority. My lord,
Section 23.
Section 23. And my lord, Section 23, subsection 1. And my lord, petitioner made an application under Section 6 of Right to Information Act 2005. My lord, page 28.
Yes.
28,
Hmm.
my lord, in reply to your application dated 2nd August 2017, you are hereby informed that as per computerized land record, the
Recorded as Sally.
as Sali. My lord, this land is Sali. And my lord, kindly see page, my lord, 21.
21.
21.
Yes.
My lord, this reply is given by the Pradhan. My lord, as per your application dated 31st/7/2017, I would like to inform you that house building plan of Dulal Chandra Safui, son of late Jitendranath Safui, approved from this office as per verbal statement. As per verbal statement, my lord, he has or she has given permission. And my lord, Dulal Chandra Safui on 26/5/1994. But now it is destroyed in the office. It is destroyed in the office, my lord. In collusion with the, my lord Pradhan, the private respondent has collected some documents to prove that with the permissions of the panchayat, he has constructed the building. My lord, kindly see my lord, kindly see section 23 first.
No, whether, what is your local, who are you to challenge this?
My lord, I am the.
How you are related with the property?
No, I have no relation.
Or
But
you are a,
whether he has taken permissions from the panchayat, my lord has constructed the 3-storied building. So I made an application under section 6 of Right to Information Act to know whether he has taken any permissions from the panchayat authority before construction his building. My lord, he has given a reply that as per verbal statement, it is, my lord, given. Permission is given. My lord, verbal statement, permission is never, my lord, given to anybody else. My lord, therefore, my lord, I will, my lord, show the section 23.
yes.
Section 23 first. My lord, kindly see section 23, subsection 1. No person, my lord, shall erect any new structure or new building or make any addition to any structure or building having plinth area of not more than 150 square meter and height not more than 6.5 meter in any area within the jurisdictions of the Gram Panchayat, except with the previous permissions in writing from the Gram Panchayat. Therefore, my lord, without any taking prior permissions of the Panchayat, nobody, my lord, can erect any new structure or any new building. Now, my lord, kindly see under rule. Rule, my lord, 17. My lord, once upon a time, I was the Pradhan of a Gram Panchayat. My lord, now, my lord, I am in this profession, and therefore, my lord, it is very much recognized how and which manner the permission has been issued by the Panchayat to anybody else who has, my lord, and my lord, Rule 17. My lord, if anybody wants to erect any new structure or a new building, he has to, my lord, make an application, my lord, in form number 4 and with, my lord, various documents such as, my lord, title deed and, my lord, the record of rights and, my lord, plan and estimate, etc. And, my lord, that application has to be submitted before the panchayat, my lord, 2 copies. 1 copy is they will, my lord, they will make it their record, and 1 copy is returned to the petitioner, the applicant, my lord, giving seal and signature and date. And thereafter, my lord, the Pradhan as well as Upapradhan has given power to inquire the matter. After inquiry, if it is found that all are okay, then my lord, it is, my lord, in a month, my lord, meeting is held, and in that meeting, with an agenda, my lord, it will be discussed that whether it is okay, and therefore permission has to be given. And my lord, it will be, my lord, taken a record on the resolution book also. Resolution book also. And my lord, kindly see Rule 18, my lord. Rule 18, payment of fees. My lord, yes, fees, my lord, Matharakka Rosid, my lord, has to be annexed with that application also. Otherwise, my lord, that application form 4 will not be accepted, will never be accepted. And therefore, my lord, as per Rule 18, my lord, fees has to be given to the Panchayat, and Panchayat will issue my lord, a receipt, and that receipt has to be annexed with that petition. My lord, no such type of document has been placed before your lordships and earlier lordships also, earlier court also. And my lord, kindly see and my lord, kindly see the record of rights. Once record of rights. Record of right. Record of rights, my lord, 24, page 24. My lord, record of rights, page 24. My lord, plot number 495, my lord, has your lordship got it?
Number, yes.
495. My lord, next column, Shali. And my lord, upon Shali, my lord, how the Panchayat, my lord, has given the permission, my lord, it is extremely, my lord, impossible. My lord, kindly see Rule 26. Classification of land for construction. My lord, if any structure or building is, my lord, proposed to be erected or constructed on any land recorded otherwise than as homestead land, that means, my lord, Vastu land, homestead land, the Gram Panchayat shall withhold, my lord, permission for such erection or construction until the applicant produce an order allowing change of classifications of the said land by the collector or any other competent authority having jurisdiction under any law for the time being in force. And therefore, my lord, this land is Sali, my lord, record is Sali, and therefore, my lord, Panchayat, my lord, cannot, my lord, give any permission to construct any new structure or building upon that plot. Then, my lord, kindly see Rule 27, manner of processing of an application. On presentation of an application under sub-rule 1 of Rule 17, which I have showed before your lordship earlier, the Pradhan or Upapradhan, any other member authorized of the Gram Panchayat in this behalf shall examine the right title interest of the applicant in respect of the land on which the structure or building is proposed to be erected, along with the building plan and the site plan, and after such inquiry as may be considered necessary, my lord, shall within a period of 30 days from the date of receipt of the application place it before the Gram Panchayat for granting, or as the case may be, refusing permission for the erection of constructions applied for. 1A, a Gram Panchayat shall not accord permission to the constructions of a new structure or building, or to make addition or alteration to any existing structure or building that is plinth area more than 150 square meter with brick or concrete, footing or height more than 6.5 meter. Mala, it is height more than 6.5 meter and without vetting of the building plan and the site plan by Panchayat Samiti or Jila Parishad having jurisdiction. Therefore, my lord, the construction which has been made by the petitioner, my lord, is totally, my lord, illegal. My lord, construction made by the private estate is totally illegal, unauthorized. And therefore, my lord, petitioner, upon being received the informations from the Panchayat, he made an application before the Panchayat authority to demolish the illegal and unauthorized structure, my lord, which has been made in contravention of the Panchayat Act and Building Operation Rule. And my lord, earlier occasion, my lord, Pradhan has filed a report. Has your lordship got it? A report filed by the Pradhan.
Yes.
My lord, kindly see paragraph 4.
Paragraph 4.
Paragraph 4.
Second page.
Second page. That both the rivalry parties of the present proceeding were present at the subject.
I'm not.
The petitioner did not submit any document before us.
I have not got it. A report dated 18th September 2023.
That is Pradhan, my
Pradhan, it is the report of the Pradhan.
yes, my
Jayanti Haldar.
Jayanti Haldar.
Yes, second page.
Second page.
Second page during the course of hearing.
During the course of hearing, they have, in terms of the honorable court's order, they have filed the report in the form of an affidavit. And my lord, the petitioner did not submit any documents before us. The private respondent number 7 submitted land testimonials, including copy LR record of rights, conversion certificate, sanctioned building plan issued by the Pradhan, Dakshin Barasat Gram Panchayat, White dated 26 May 1994. Next para, I compared the submitted documents, photocopies with its original and retained the same with us. On earlier occasions, Pradhan has, my lord, given a reply that in terms of, my lord, the verbal statement, the permission is given. Now they have, my lord, filed a report wherefrom it is evident that conversion certificate, there was no conversion certificate. And my lord, when they have, my lord, got the conversion certificate, my lord, kindly see. When they have got conversion certificate. Conversion certificate. That's it. My lord, kindly see conversion certificate, which is at page, my lord, 6. 6, 4, 5, 6. My lord, page 6.
Page 6.
Page 6.
Of
My lord, of affidavit of a report in the form of affidavit filed by Pradhan.
এইখানটা আসুন তো এই রিপোর্ট ইন ফর্ম অফ এটা তো পিটিশন এটা অ্যাপ্লিকেশন ক্যান এটা কাটুন তো এটা কি ফর্ম অফ এফিডেভিট Except for the report. এই যে, এটা কত? ও page 6, yes.
Yes, page 6, my lord. But this is the conversion certificate which they have, which the Pradhan has annexed with his report. My lord, kindly see when, my lord, conversion has been made. My lord,
1st August 2022.
1st August 2022. And my lord, they have, my lord, rightly or wrongly, whatever it may be, they have said that permission has given in the year 1994. When, my lord, the status of the land was Sali, that means Jol.
Sali means cultivated.
Cultivated land. And it is not the Vastu land. And my lord, they are saying that permission is given in the year 1994, but conversion took place 1/8/2022. At that point of time, the land was not Vastu. And on Sali, my lord, permission was given. My lord, permission can never be given because, my lord, I have sought the rule 26, my lord, where, my lord, it is clearly stated that if any structure or building is proposed to be erected or constructed on any land recorded otherwise than as homestead land, the Gram Panchayat shall withhold permission for such erection or construction until the applicant produce an order allowing change of classification of the said land, where he proposed to erect any new structure. Therefore, Panchayat cannot, issue any permission to that person who has already, made an application for permission on Sali land.
Yes.
And my lord, kindly see the plan who is the Pradhan has annexed with his report. It was paginated. Alert 8, page number 8.
Yes.
Alert, he has annexed, alert the plan, alert issued 26/5/1994. Alert, bottom column, bottom. And my lord, at that point of time, the land was not converted. Land was, even if it is assumed that this is the correct document, it is a manufactured document. Even if it is assumed for the argument's sake, my lord, it is original document, then my lord, at that point of time, my lord, land was Sali, land was Jol. And therefore, as per Rule 26, Panchayat has no authority to issue any permission to that person.
Yes.
And my lord, if anybody, my lord, earlier I have submitted before your lordships, if anybody wants to erect any new structure or building, my lord, he has to submit, my lord, the application in form number 4. My lord, your lordships kindly ask them to, my lord, place before your lordships that they have submitted, my lord, form number 4 with all documents. They have never, my lord, placed before earlier, my lord, court. My lord, they have never placed it.
This matter was earlier taken up by any coordinate bench.
Yes, my lord, coordinate bench. My lord,
So what order was passed?
Honorable Justice Saugato Bhattacharya. Saugato Bhattacharya.
No, same writ petition. No earlier writ petition.
No, same writ petition. And my lord,
So you have two grounds. That is the erection or building has been, construction of the building has been made on a surly land prior to its conversion to a Vastu land, and the sanction was given without following the prescribed procedure.
yes.
Rule 18, Rule 23, and
Also, my lord, also my submission that it is not the original document, it is manufactured document. Subsequently, when the case was initiated, they have prepared this document. My lord, if it is not, then my lord, they must, my lord, submit before your lordships form 4. And my lord, with Matharakar receipt. Otherwise, my lord, Panchayat cannot consider, can never be considered as per my lord 17, 26 and 27. 27 rule.
yes,
And therefore, my lord, the entire building, now it is 3-storied building, my lord, 6.5 height, more than 6.5 meter. Panchayat can never be, my lord, permit a 6.5 meter, above 6.5 meter. He is, my lord, jurisdiction, his jurisdiction is up to, my lord, ground floor, first floor. And therefore, my lord, the entire building has been erected without any permissions of the Panchayat upon my lord Saliland, and therefore, my lord, my humble submission, my lord, direction should be given to demolish this structure. This is my humble submission.
yes.
I appear for the state respondents, there are certain other things which had happened in the meantime during pendency. There was an instance where the petitioner alleged that he was beaten up by at the instance of the private respondents. So at that juncture, my lord was pleased, the earlier bench was pleased to direct police posting at the house of the petitioner. That has been continuing for the last 1.5 years. There's no new instances, no new further allegation from the petitioner. My lord, those may be relieved. No, my lord, the orders passed are before your lordship.
He was heated, and therefore, my lord, police was posted there.
My lord, that's what I'm submitting. I don't know if I have. My lord, kindly seize the last 5 orders.
Following an order passed in this writ petition.
The orders passed in this writ petition, my lord, these were taken up out of turn by the by Justice Bhattacharya. My lord, kindly seize last 4 orders. All instances with regard to that only. He has been allegedly beaten. My lord, there's a report filed by the CID probably in this matter as well. I'm only praying because they are the only answering authority and the Pradhan. The Pradhan was appearing separately by Mr. Indrajit Chattopadhyay. Now, the state respondent are still deputizing 2 police personnel at the residence of the petitioner. Though that may be relieved because the state is expending, incurring a huge cost. There's no new instances, no allegations, no instances. Those may be relieved. That with regard to state respondents, that are my submissions. The rest of the.
Now, my lord, 2 things. My lord, first, your lordship had put a question to the petitioner. What is your locus?
Take the mic, yeah.
My lord, first, your lordship, my lord, has put a question to the petitioner. What is your locus standi? That, my lord, answer has not come yet. My lord, this petitioner being a, my lord, practicing advocate of this court, my lord, is habit of filing repeated, my lord, writ petitions on the same self-ground. This writ petitioner. Now, my lord, what happened, my lord? My learned friend, my lord, has relied upon, my lord, 2 things. One, the West Bengal Panchayat, Gram Panchayat Administration Rules 2004 and, my lord, Section 23 of the Panchayat Act. Now, my lord, lordship would kind enough to read. My lord, this, I'll place it before your lordship.
You have bought only one book.
Panchayat Act.
Panchayat Act, I can.
My lord, kindly see this book.
Oh, give me.
আপনার বই নেই এখন? বই নেই?
Panchayat Act 23, yes.
Yes, kindly see section 23. My lord, kindly see section 23. No person shall erect any new structure or new building or any make any addition to any structure or building in any area within the jurisdiction of a Gram Panchayat, except with the previous, kindly marks these 3 lines, except with the previous permission in writing of the Gram Panchayat. Very clear, provision is very clear. This is the parent provision. Now, we'll kindly see, provided that such erection of new structure or building or such addition to any structure or building as or such permission of the Gram Panchayat shall be subject to such rules as may be made by the state government in this behalf.
Provided next proviso or proviso 2, yes.
Yes.
Provided further such erection of new structure, new building and permission from the Gram Panchayat shall be subject to rules as being made by the state government.
This is the provision. Now, my lord, lordship would kind enough to take up the West Bengal Gram Panchayat administration rules, which my learned friend has, my lord, placed.
It is not there. My lord, one copy, my lord, Xerox copy, my lord, may I hand over?
একটা পঞ্চায়েতের বই ফই এনে রেখে দেবে।
Yeah.
Yes, administrative rule.
Gram West Bengal Panchayat, Gram Panchayat.
Got it.
My lord. ওই তো রয়েছে।
হ্যাঁ, yes.
রুলসটা আছে ওর মধ্যে?
হ্যাঁ, রাখুন।
রুলসটা আছে?
Yes.
Now, my lord, kindly see the very fast, my lord, the rules, my lord, at the
Try to find it out. Gram Panchayat administrative rules.
2004.
You got it, yes. Page rule 17.
Before that, at the very initiation of the rules, kindly see very first page of that rules. Part 1.
Yes.
Kindly see the notification. Kindly see notification dated such and such, dated 23rd November 2004. Kindly see, in exercise of the power conferred by section 224 of the West Bengal Panchayat Act 1973, the governor is pleased to hereby to make after previous publication as required by subsection 1 of the section the following rules. Therefore, the governor, my lord, had these rules were framed sometimes in 2003, and the governor has given assent to the rules in 2004. Therefore, my lord, this rule does not say, my lord, it has given a retrospective effect. Therefore, my lord, original provision, my lord, the report says my construction was in 1994. I will show documents also. 25th June, my plan was sanctioned. Thereafter, my client was a state government employee. He applied for loan in his own office. Then, my lord, after being satisfied with the plan, now, my lord, office, my lord, sanctioned loan to him for purchase for construction of this. Therefore, my lord, in 1994, 2000 rules were not there. Then, my lord, what was there was only section 23. Section 23 says, my lord, again, my lord, comes back to section 23. It's only, my lord, a permission written in writing. That's all. It's only a permission written in writing. That is the only requirement, my lord, in the parent act. Now, my lord, be that as it may, since, my lord, my learned friend had raised a point that I have never applied for in Form 4. My lord, this is the Form 4, my lord, which was applied for. Although that was not required at that point of time, but my office did not give me loan since there was no, unless plan is sanctioned. Kindly see at the extreme left top, Form 4, although that was not required. Kindly see it was applied for. Then, my lord, next, my lord, the plan is sanctioned. Okay, kindly see the plan was placed before the Gram Panchayat. The sketch, my lord, the map, then it was sanctioned. Kindly see, my lord, the date is given in at the bottom, my lord, 25th. This is also reflected from the report of the Pradhan also in 1994 itself. In 1994 itself, it was there. And, my lord, the construction was made, my lord, in terms of that plan. Now, my lord, kindly appreciate one thing. There was, my lord, my learned friend also says, now there was, my lord, it was not converted into Vastu. It was not converted into Vastu. My lord, where is that stated? That is also stated in the rules, not in the parent section 23, say rule 27 or 26. Well, rule 26 or 27 came into effect from 2004 in the rules. In 1994, when the plan was given to me, Lordship would consider whether that was at all the requirement at that point of time. And whether that was at all the requirement. Kindly reads, my lord, again 26 of the rules. That rule 26 has also came with the 2004 rules. 2004 rule says it was drafted in 2003. Governor gave assent to, my lord, in the year 2004. Finally comes to, my lord, the rule 26.
Yes.
If any structure or building is proposed to be erected or constructed or any land recorded otherwise than homestead, homestead land, the Gram Panchayat shall withhold permission for such erection or construction until the applicant produces an order of allowing change of classification of the said land by the collector or any other competent authority having jurisdiction under any law for the timing. Definitely, that is the law after 2004. But what was the law in 1997? There was no rule at that point of time. Therefore, we have to resort to the parent section of section 23. 23 says only a written permission in writing. Because my client was a government employee, he took loan from the office, he may not prepared a plan, submitted it before the Panchayat authority, they have sanctioned it. Otherwise, requirement was only a written permission from writing, in writing. Now, my lord, Lordship would kind enough to see the report now. The page, my lord, unpaginated report, it should be page, my lord, 9 or something.
Page 9,
Probably
yes.
Should be page 9, annexure B.
Yes, annexure B, yes.
My lord has kindly similar. This is pursuant to the Lordship's coordinate bench. My lord, report was filed, my lord, by the Pradhan. Kindly see, this is a 3-storied building. Hereinafter, having thereafter follows the vertical height of the said building is 9.50 meter without staircase room attic, 12.3 meter with staircase room attic. On the ground, the horizontal length of is 29.6 feet and the breadth of the building is 24.3 feet. The ground floor floor has 2 rooms, 1 kitchen, 1 washroom. The first floor has 2 rooms and 1 kitchen and 1 washroom. However, the second floor does not have any room. Apparently, it appears to me that the construction is not a new one, because it was done in 1994. How will the Pradhan say that it will be a new construction in Millard when the report has been filed? Now, Millard, another Millard, kindly see Millard this Millard notification which has come Millard by the state government notification. Kindly see.
Yes.
Kindly see, my lord. Here, my lord, Lordship knows under section 4C and 4D of the West Bengal Land Reforms Act,
Yes.
there is a provision, my lord, for conversion. What is the effect of that conversion for non-conversion? My lord, either, my lord, civil imprisonment or fine. There is nothing, my lord, given in the statute for demolition. Kindly see, my lord, even by this notification, that provision has also been diluted by the state. Kindly see, my lord. Kindly see, I'm placing it in its entirety. The West Bengal Land Reforms 3rd Amendment 2017 provides for regularizing unauthorized conversion of land exceeding 0.3 acres situated in the areas falling within the limits of municipal corporation, municipality, or the plots of land Kotha. And yes, municipal and or any other plot of land of exceeding 0.08 acres in the area not falling. I come under this category, not falling within the local limits of municipal corporation or municipality, because this is a panchayat, not falling. Other than any other water body or the case to case basis on its merit. The Amendment Act has come into force with effect from 17 November 2017 by this department such and such, wherein it is clear that unauthorized conversion of land beyond the date cannot be taken into consideration for regularization. The fact the rules and fee structure of the same has been prescribed by notification dated such and such. In continuation of the above, the following guidelines shall be followed by the collector and shall be taken into account while processing the application. Therefore, post facto processing the application can also be done. Kindly see, my lord. I'll show to your lordship. Para 1. In respect of unauthorized conversion involving land not exceeding 0.03 acres situated in the areas falling within the local limits of municipal corporation or municipality or any other plots of exceeding 0.08 acres situated in the area not falling within the municipality, local corporation, municipality, the petition may be disposed of by the following by prescribed authority in accordance with the existing provision or laws. Therefore, if the conversion has already been made, now the conversion in the record of rights can be made. Well, that is one. Kindly see cases of unauthorized construction before 7th November 2017 only are to be considered under the amended provision. Milord, my case is of 1994. Milord, my conversion was done in 2022 in pursuant to this. Kindly see, the collector under 4C of the West Bengal Land Reforms Act shall receive duly filled up forms as prescribed under the amended rule up to a period of 6 months from the date of final publication of the said rule. Application pending before the level of divisional commissioner falling under the purview of the amendment shall be returned to the respective district collector or completion of necessary formalities. The collector shall obtain views, no objection from the relevant line department as required for processing the application. Upon completion of the examination and inquiry, the cases shall be sent to the category wise based on the present mode of land used to this department along with comments, views, specific recommendation of collector and finalization. The collector shall ensure completion of due diligence, examination and inquiry within 21 days and the proposal to this department by specific messenger. On approval, concurrence of the department, collector shall issue necessary certificate of conversion in the prescribed format and complete required action in the Guchitra module. A report showing realization of fine and quantum of land involved in the regard should be sent to the department through Director of Land Records and Surveys, West Bengal on monthly basis. Then, Milord, in case of Milord, even in 1994, this was not required. Let us suppose, Milord, my learned friend has the best case. It is required. Let us assume that. In that case also, Milord, government says, Milord, if it is unauthorizedly filled up, you take fine, you regularize it in the land records. 4C, 4D has been dilated. Therefore, in 2022, from Shali to Bastu, it has been done. Where is the illegality? May I ask myself?
My learned friend submitted before your lordships that in the year 1994, there is no rule, building operation rule. Therefore, each construction is totally governed by only section 23. My lord, in the year 1973, the act was, my lord, formed. And thereafter, in the year 1981, the rule is formed. A rule is made. My lord, kindly see the rule. In the year 1981.
Not being relied upon.
My lord,
my learned friend in reply cannot make out a new case.
kindly see.
He is now saying, Milord, rule is formed in 81. He did not. He placed reliance in 2004 Act. I am objecting to this.
Also rule
No.
1981.
That is repealed.
And my lord, it is not repealed.
Definitely.
This is not repealed. My lord, kindly see.
He placed Milord 26 and 27. He cannot take not new state in reply.
23, my lord, 23 E. My lord, 23E.
23
E.
E.
E, my,
E 23.
my lord,
23 1B 1 2 3 4.
23E. It is marked. Classifications of land, my lord. Kindly see this.
No, what is this? Oh, it is Bengal Panchayat Law Compendium. 23E rule of 1981.
1981.
Okay, 23A.
Control
A,
of building operation.
yes.
And thereafter, it is, my lord, modified subsequently, amended. And my lord, 23 A, E.
Yes.
Classification of land for construction. If any structure or building is proposed to be erected or constructed, my lord, same thing, which is it in 2004 and my lord, 2081. Same, my lord, same language. If any structure or building is proposed to be erected or constructed on any land recorded otherwise than homestead land, the Gram Panchayat shall withhold permission for such erection or construction and produce for allowing change classifications of the state land by the collector or any other competent authority having jurisdiction under any law for the timing in force. And therefore, my lord, at that point of time, there is a rule, building operation rule, in the year 1981. And therefore, my lord, now they are saying that Form 4 is not required under section Rule 17. And now they are placing, yes, it is Form 4. Just now, my lord, my learned friend submitted before the lordship, it is Form 4. They have never, my lord, submitted earlier occasion that Form 4 has been submitted before the Panchayat and that according to the provision, my lord, it is sanctioned. Nothing. My lord, time to time, my lord, they are submitted one after another document. My lord, not at a stage, my lord. And therefore, my lord, what my learned, my lord, friend submitted before your lordship, my lord, only Rule 24 has come, and therefore, these constructions of the building is not, my lord, within the 2004. My lord, 1981, there is a, my lord, rule. And therefore, my lord, Panchayat, my lord, has never, my lord, cannot permit any permission to anybody, my lord, until and unless the land is, my lord, changed from Shali to Vastu or Jol to Vastu. Therefore, my lord, his submission is not correct.
Now, from Rule 24, what are you reading?
My lord,
What are you reading from Rule
my lord, I am reading,
2004 Rule?
81.
Rule 81 for 2004.
Oh,
Huh.
my lord, 2004, my lord, kindly see, I have already handed over one Xerox copy. My lord, kindly see, my lord, Rule 26.
23.
26.
26.
26. Same language is here also. But kindly see.
Now, where is the rule parameter?
26. Classification of land for construction.
No. It is specific. Rule 26.
Rule 26 of 2004.
There was any rule which is parameter to Rule 26 of 2004?
2004.
Whether in 1981
Yes, madam.
there was any rule which was parameter to Rule 26?
But kindly see, I handed over it. I handed over it already. 81, Rule 81. Fifty-one, 23E.
What is 23A of Rule 81? That is 22 of Rule 22. 20 Rule 22 of 2004.
22 of 2004.
What was Rule 23 in Rule of 1981? That is 22. Same provision has been incorporated in Rule 2004.
Kindly see.
You take.
26 and
You take.
23.
You find out any provision which is parameter to section 20, Rule 26.
Compendium, my lord, I am not getting the 81 rules, my lord. Very
26.
difficult.
81 rules.
26 and 23E. Allah, same. 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 Allah, classification of land for construction. Here also classification of land for construction. Same.
No.
Yes, my lord. Kindly see. Same thing.
23E তো নেই।
এই তুমি আমার কাগজও দিচ্ছ না, বই দিচ্ছ।
এই তো নিয়ে নিন, হয়ে গেছে। 23E কোথায় আছে? 81 rules এর?
Allah, it is marked by pen.
23E.
Yes, ma'am.
Have you got?
No, my lord, in this bunch there is no 23.
23E of Rule 1981. 23E.
Yes, 23 has, my lord, 23A, 23B and 23C. এই তো।
এটা দিন। Got it? 23A, E, 23E, E for elephant.
पता नहीं।
Now you see 26 of 2004.
Same. Yes. Now, my lord.
So that provision was very much there in 1981 rule.
1981 rule, my lord, as of today, that is repealed. If it is at all there.
In 1994, it was in force.
It was in force.
When you constructed the house. So admittedly, you constructed your house on a land which is sully.
No. But it does not say, it says it will withhold. It does not say any consequence of demolition.
So it has not been, permission should have not granted until 2022.
That is there. But it has been further diluted, my lord, by the notification of the government. That is a mere, my lord, now, my lord, it is only, my lord, ministerial. Now, my lord, it is ministerial because the government has, my lord, being the superior authority, has, my lord, given, my lord, the permission for change of, my lord, in case of unauthorized, my lord, conversion, it has given permission, my lord, for change of.
And my lord, kindly see, my lord, section 23, 5. 23, 5 and 6. Where, my lord, section itself has given a power of to the panchayat. My lord, if any, my lord, unauthorized construction, illegal construction is made without any permission, prior permission of the panchayat, Pradhan has demolished. Pradhan can demolish it. Now, my lord, it is changed. My lord, if Pradhan, my lord, found that there is any illegal construction, my lord, he will give an opportunity of being heard to the parties, and thereafter, my lord, he recommended to the SDO, my lord, concerned SDO, my lord, to take a decision, final decision. My lord, kindly see 23.
Where is that circular of 2017? Have I given you back? 2017, देखिए. Yes, have you brought the Land Reforms Act?
LR Act. LR Act ano, LR Act ano. Ano.
Manual, the manual is required.
My lord is
এই ইয়ার মে তো ম্যানুয়ালটা এনে রেখে দেবেন তো ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস ম্যানুয়াল ম্যানুয়ালটা নেই
I've sent my junior to land.
ল্যান্ড রিফর্মস অ্যাক্ট yes gone ল্যান্ড রিফর্মস অ্যাক্ট ম্যানুয়াল 166 ম্যানুয়াল yeah
All টানতে বল manual. তুই চলে যাও।
okay the state taking note of this fact as on date state has converted the land.
My lord, it is
Actually, collector is the authority to convert.
yes, my lord.
Taking note of this fact that the panchayat granted permission based on that the construction was made. Now, as on date, the collector has converted.
My lord, in the year 2022, the land was converted.
And what
Before
was he
that,
doing,
before
Milord, from
that, my lord, land was
1994?
not converted. And they have made a construction.
Well, what were they
My lord,
doing in the year
possibly They are
1994?
saying that in the year 1994, my lord, 1994, my lord, they have constructed without taking any prior permissions of the panchayat, though they have submitted before your lordships. My lord, here and there, this document, that document, my lord, entire document, they have not filed. Never, they have not filed. My lord, Form 4 and Form 4 with, my lord, title deed and, my lord, record of rights and, my lord, Matharakar receipt. Each and everything has to be submitted
That
before
is
the
there in
panchayat,
French.
and thereafter panchayat will inquire the
It
matter.
was submitted. It
Every
was submitted.
panchayat writes that in their
It will not be a panchayat or neither the panchayat nor the authority is duty bound to supply it to outsider.
And what was he doing from 1994?
When they have Matharakar receipt is there. And when a resolution book has to be submitted that they have taken a decision in terms of the, my lord, agenda, that permission has to be given to the, my lord, the private respondent. A resolution has to be given. My lord, panchayat has submitted the report, my lord, without, my lord, annexing these documents, my lord, material document. This material document, he has submitted this report without material document. And therefore, my lord, entire document is manufactured document. Entire document. Manufactured document, subsequently.
And you should have come in 1994, not in 2008.
Maybe. Subsequently,
Locus
they have,
standi point has not been, my lord, answered.
when, my lord, case is initiated, my lord, they have prepared in this way, in this fashion.
আর এই ল্যান্ড রিফর্মস অ্যাক্ট নেই এ কি
কোথায় গেল আনতে মনে হয় দেখি
ওকে
ও দেখেছিস তিনটে পয়েন্ট বললে তিনটে এটা দেখে অ্যাকসেপ্ট 0.0 হ্যাঁ দ্যাট ওয়াজ রেখে পড়ি বলে দিচ্ছি No. My lord is looking for the manual, my lord.
Manual, got it? 166.
Yes, yes. Yes. So this is also there in the provision itself. C4.
Yes, yes.
My lord is manual.
Manual 166 has been given power.
Yes, yes, yes.
Hmm?
To the collector.
To the collector to regularize. And 4C,
Yes.
6 also has given power.
No, my lord.
The state can regularize.
No, my lord, the year 1990, according to them, my lord, in the year 1994, my lord, permission.
Forget about 1994,
Permission
Land
was-
Reforms Act 1990 55.
55.
55 section 4C6 and West Bengal Land Reforms Manual 166. 166 has given power upon the collector to regularize conversion.
Really?
It is the state.
No, no.
It is the state. State is the ultimate the owner of the land. You say in this way. State has settled the land in favor of its riot, that is its citizen, for a particular purpose. The land will be used for residential purpose, for commercial purpose, a pond for pisciculture, and no one permitted to change the use, mode of user, without taking permission from the land collector. But if it is found that land, the mode of use has been changed, then collector can regularize the conversion.
Collector can regularize it. But he, my lord, consume power. What, my lord, in the year 1994, when, my lord, the construction has been made.
Admittedly,
My lord,
construction.
at that point of time, there was, my lord, it is cultivated land. And my lord, in the year 1981, the rule, my lord, says that without, my lord, change certificate submitted before the panchayat cannot, my lord, permit any construction, new construction. My lord, then, my lord, in the year 2022, my lord, land is converted, and therefore, my lord, illegalities will be cured.
Challenge that.
Illegalities will be cured, my lord. What the my lord, private respondent has made, that illegalities has cured. And how the panchayat, my lord, in the year 1994, my lord, in terms of rule 81, my lord, has given the my lord permission. And therefore, my lord, this permission is, my lord, manufactured document. Everything is manufactured. It is not in order.
That you have to, evidence is required to give that answer. Expert opinion, handwriting expert opinion,
No, no.
Department of Question document.
It is, my lord, evident.
Okay.
It is evident in the year 1981, rule is there. And, my lord, in spite of that, my lord, according to this, if it is, my lord, correct, my lord, in spite of that, Panchayat has given, my lord, permission. He cannot. Panchayat cannot. And, my lord, Panchayat has filed the report, and in that report, my lord, how the permission has been given, no, my lord, document has been annexed with this, my lord, report.
Yes.
My lord, how and which manner, my lord, this permission has been, my lord, granted. Sometimes they are saying in terms of verbal.
Okay, that's all. The building of the private respondent Next. 27.
Lord, I am for the petitioner, my lord. There is my application for recall as well as for condonation of delay. If your lordship kindly allows hearing.
Oh, I am to adjourn this matter because despite sending requisition, the application has not been sent by the department. It has not been tagged. তো কবে হবে? কালকে দিতে পারবেন? কালকে পাবেন? কি করে কনফিডেন্স করছে? If it is detected today, tomorrow it will be given. ঠিক আছে? It is detected tomorrow, then next week.
In that case, I can, if it is not found, in that case, I can hand over a copy.
Okay, let us say, let them
Yes.
make another report. আপনি করে বলুন যে জাস্টিস বলেছেন।
I'm grateful to your lord.
Okay.
My lord, pursuant to lordship direction, from the state and also my lord the
Yes.
private parties. So the thing by registered post later, I have taken the tax report. Most of them have received.
But may I file my affidavit in opposition?
Have you filed reply?
Yes.
Oh.
Yes.
No, your reply is not with the record.
I have not also been served.
Reply.
এখন আর আসে না তো।
I have given to them
এখন কোর্টে আসে না।
Mirza Kamruzzaman.
He is not coming to the court last 3 years.
It is not with the record also. Mr. Mustafa.
Petition থাকে দিতে।
Mr. Mustafa, kindly find it out. It is with you. It has not been.
Not on my record. Take to fight the 18 দেখি। It's a 9.
এটা তো আমার opposition.
Service.
নেই।
Evident reply is here.
Oh, it is with the.
এটা আসেনি।
দিন ওপরই দিন।
My lord, this is a peculiar case, my lord, of hooliganism. For last 3 generations, we are the owners of the property. My lord, once upon a time, my lord, it was in the name of the grandfather, then my lord, grandmother, then mother, then my lord, the private respondents, my lord, filed a suit. They lost the suit. Then what happened? My lord, they preferred appeal in the landed court below, district court. An order was passed. Then, my lord, we challenge in the second appeal. But in second appeal, my lord, if your lordships from page 37 onwards, the story is clear. They filed a partition suit. Ultimately, they lost. The private respondent went to the Supreme Court. There also they lost. But there, my lord, as and when we are entering in our land, there we are to some extent gentlemen, my lord, educated people, gentlemen. The hooligans are continuously obstructing, not allowing us to cultivate our land.
No, you filed a partition suit.
Not we.
They filed a partition suit. Partition suit was degree, preliminary degree or final degree.
Partition suit was, my lord, dismissed.
Dismissed, yes.
Against that, my lord, dismissal order, they preferred an appeal in the district.
We are not, my lord, co-sharers.
You are for the private respondent.
Wait, my lord, she is assisting me.
Oh, so who is for the private respondent? There must be some private respondent.
Today, nobody is appearing on behalf of the private respondent. What happened in this matter, my lord?
writ petition, my lord, is essentially, my lord, on the issue of police inaction. On the ground, police did not take any steps in terms of their complaints. Essentially, my lord, writ petition on that
We have
ground.
taken.
My lord,
some
we have taken steps and we have registered an FIR and we have, my lord, after conclusion of investigation, we have filed the charge sheet. Matter ends here, my lord.
No, that is not that is not.
Yes, so what else
But
can we do?
they are, but it is my property. My lord, they went up to Supreme Court, they have lost, but they are not, they are continuously obstructing. We, my lord,
But one specific
no,
written
no.
complaint, my lord, we have taken steps.
আপনি শেষ করেন। আপনি শেষ করেন।
বলুন না।
Now, my lord, they lost in the Supreme Court. So now we have got the absolute right to enjoy our property. Then, my lord, we kindly see, my lord, page 54. We requested the police that you take steps against the miscreants so that we can cultivate our land peacefully. But that has not been done. Even when very recently, we requested that the same problem is going on. Then in September 24, my lord, I wrote a letter to the inspector in charge that this is going on, please take action. The petitioners also, my lord.
My lord, his petition is of 2029.
Yes.
My lord, my lord, now he is showing a document. I do not know whether it's not been, it is not in the part of the writ petition, my lord. No supplementary affidavit was made, my lord.
I am not suing, I am just,
My lord,
I am just telling the facts. Now, my lord, kindly see page
not
50.
beyond the writ petition.
With due respect, I understand such and such.
This is the cause of action.
Draw your kind to the fact that I, along with my brothers, were gifted the land as given in the schedule by my grandmother, such and such, since deceased, who was the recorded owner of the sale. After the death and on the becoming the owners of the said land, steps were taken for recording the same. Recording has been done. Then that the complainant and his brothers are the absolute recorded owners and they have got unclouded right, title, and interest over the subject plots of land, and they have been in actual physical possession of the said land on payment of rent to the government. Then unfortunately, one such and such filed a case, petition suit number such and such. Suit was dismissed. Against the said order of dismissal, the plaintiff filed an appeal before the London District Court, District Judge Court, Murshidabad, in which some portion of the land was decreed in favor of the plaintiff. That against the said judgment and decree passed in title September such and such, the complainant preferred an appeal. The Honorable High Court, being SNMS in the Honorable Court, initially granted stay, and ultimately the judgment and order dated September to set aside, and the order passed in title appeal number such and decree passed by the Assistant District Judge Murshidabad on July 2089 in petition suit was confirmed. Gain brothers lost the suit in the High Court. That against the judgment and order passed in essay, the legal heirs of the plaintiffs moved to Honorable Supreme Court by way of special petition. By the order dated November 13 to 15, the Honorable Supreme Court was pleased to dismiss the SLP for non-prosecution. The legal heirs of the plaintiffs lost from the trial court to the Honorable Supreme Court. The complainant and his brothers, as usual, being the bona fide owner, possessor of the said land, have been cultivating the same as usual in some portion. There are some residential house. That as usual, the complainant and his brothers have cultivated ruby crops at that time, my lord. Next para. When the complainant and his men were in the field and started raping the Musuri, the local association, such and such, that, my lord, is still continuing. That is my case. As their musclemen, large number, as and when you are going, in the affidavit in opposition, they have admitted, they have taken, but, my lord, we want that our cultivation should be ensured by the police.
That cannot be done.
After losing in the Supreme Court, how they can, my lord, obstruct? If I am putting the question to myself, the petitioners all along making prayer before the police. Kindly see the judgment, my lord. My lord, Mr. Justice Sen was pleased to of the judgment.
Lord, may I assist you, Lord, your lordship, Lord?
So this is question of my right.
May I
to
assist
property.
you, Lord? Lord, cause of action, Lord, arises, Lord. If your lordship, Lord, reads, Lord, looks at page 56, has your lordship got it, Lord, page 56?
56, is it an incident of 22nd
Lord,
February?
second and third paragraph. This is the cause
22nd
of
February
action.
of 2019.
This is the cause of action.
just read the
Petition has
best
been
of-
filed. Police did not take any action. Milord, if your lordship kindly takes my affidavit in opposition regarding this allegation, Milord, at page 7. Your
Yes.
lordship, page 7 of my opposition, Milord.
Page 7.
From the top, Milord, just after 7th line.
Yes.
Just after 7th line, Milord, from the top.
Yes, yes.
Sentence starts, I also say. Has your lordship got it?
Yes, yes.
I also say that on the basis of the written complaint, this is the written complaint made by the writ petitioner against the private respondent herein a specific FIR was registered under section such and such of the Indian Penal Code, being Domkal PS case such and such, and after completion of investigation, a charge sheet was filed before this jurisdictional criminal code on 30th July 2019. Regarding other contention, Milord, I reserve my mind. Milord, this is the complaint. We have taken steps. Milord, matter ends, Milord. We have taken steps. No cause of action lies just now.
That is still
And
continuing.
Milord, if your lordship kindly takes their reply, in their reply they said page 7. Your lordship kindly takes their reply. They admitted, Milord. The first line, page 7. Your lordship kindly see paragraph 8.
Yes.
Paragraph, second paragraph in paragraph 8, Milord. First line, I say that of late the police has taken some steps. Milord, what else we can do, Milord? After registration, after making a complaint, FIR was registered. Page 7 of their reply, Milord. Paragraph 8, second paragraph, sub-paragraph of paragraph 8, Milord. Your lordship.
I say that of late police has taken some.
But your lordship kindly stops here, Milord. We have taken some steps. They have admitted here.
Reading
And Milord, after conclusion of Milord investigation, we have filed the charge sheet. Nothing remains there, Milord, against the police in action.
Because, my lord,
Now, what do you want? Police will depute me
Forever.
near to your agricultural land.
ensure our cultivation.
Why?
Huh?
Ensure our
So
cultivation.
on every season, police will come.
And
They
that is
will
of 2020,
stand with you,
2019.
and you will. Today you will plow their turn. Tomorrow you will irrigate your land.
Subsists.
No, but
Today no cause of action subsists.
Second some steps, but the same are not effective to safeguard the
According to him, it is not effective. Milord,
proprietary rights and interests.
if we have not taken any effective
Petitioners
steps,
are, my lord, yes, he is, my lord, he will not allow me to. The private are very dangerous, but effective steps would be taken against them.
Milord, if he is aggrieved by the charge sheet, he has his remedy before the jurisdictional criminal court. Certainly not filing a writ petition before your lordship, Milord.
They lost.
He has his remedy in the.
Why you are championing the cause of the?
No, I am not championing. I am the no.
Okay.
My lord, kindly, my lord,
No, if any incident occurred, you will approach the police authority. But it is not possible that the police will go on everyone. Yes, I am standing here, you plow. I am standing here, you irrigate. I am standing here, you so the
but in rural areas, they are non-state actors.
If he is aggrieved by, he can file his, Milord, he can pursue his remedy in the jurisdictional criminal
if
court.
any incident occur, then you will pursue your legal remedy.
Kindly, my lord.
Uh-huh.
My lord, we are, my lord, to some extent, all are educated people. The miscreants, they never contest. Even going to the Supreme Court, they lost. But as and when we are going, they are obstructing. We have got someday putting fire, burning our houses. Each and every time we are making.
You file a suit seeking degree of permanent injunction against them.
No. My lord,
What can be done?
they have lost. Your lordship kindly make an observation.
It's a first cause of action.
Untoward incident happens, the police will take, we shall approach the
Milord,
police.
your lordship will not have observed anything.
Not required. I said the present petition has been prepared, primarily praying for a direction upon the respondent number 2
the LIC, my lord. That
Lords.
has been repudiated on the ground, fraud committed by their staff. There is
By the?
By their staff, own staff. CBI filed charge sheet, there is no allegation against the investor. There is no name in the investor. There is the matter. Very interesting matter, my lord. Several occasion coming before your lordship and they are taking adjournment.
Lordship, in this matter,
Since
Mrs.
long-
Shoma Roy Chaudhary is appearing for the
Huh?
Mrs. Shoma Roy Chaudhary is appearing for the LIC. I am praying not today, Lordship.
Lordship, this is the situation I am suffering since 2019.
So why
Last
you
occasion,
are on every occasion
Kindly
you
see
take
last
that?
order, my lord.
Some emergency she left to the court, Lordship.
Emergency, maybe today is emergency, today.
Lordship, I am
These
praying only not
two days, preceded by a long weekend and followed by a long weekend, everyone is difficulty. Most of it has become ill. What can be done?
I will surprised to know that.
Okay, not this week, but yeah, I am keeping
Kindly
it.
take it
Lordship, on
tomorrow.
the earlier occasion when
My learned friend,
when we are appearing, but they did not appear before the Honorable Justice Vishwajit Basu.
kindly
Lordship.
take it tomorrow, my lord. My learned friend made a request to me. Kindly take it tomorrow. She will come.
So you should have said so.
My lord, I am saying about the matter, my lord. Why I am suffering since
You are
long?
instigating the court.
No,
Huh?
I am requesting her.
Oh,
I am
yeah.
requesting her.
Ah,
Hold that hand.
saying that and
I am requesting
always
her.
they are taking time. Always they are taking time.
Did not appear.
They come tomorrow, come tomorrow.
No,
Come tomorrow.
kindly, my lord, take the matter on top of the list because I am suffering, my lord. There is a very interesting matter, my lord. There is a several judgment I have to show before lordship. My lord, once, my lord, Supreme Court, my lord, rule that once receipt has been issued to the policyholder, you cannot repudiate the claim.
They are bound to honor.
That is the matter.
They are bound to honor. Okay, it would be looked into.
One thing that, my lord, fraud committed by their own staff. CBI filed charge sheet. There is no allegation against me. That is the matter, my lord, before your lord.
Actually, there are some motions matter. Thereafter some returnable matter. Those has been fixed by earlier. Thereafter, this matter will be placed. Don't automatically.
Well, request, my lord, kindly top of the list if possible.
No,
if permit.
not this way. Not this way. Top of the list, no. It would be placed under motion. Thereafter, returnable matter. Thereafter,
Lordship.
okay.
Lordship. Oblige, my lord.
Yes. Next.
Lordship, I beg to appear for the petitioner, your lordship.
My lord, I am praying leave to file a.
I am appealing for the Union of
Lordship, as per the last direction, lordship, kindly seize the last order, lordship. They have been given the last chance to file the report, lordship, with a prior copy served to the petitioner, lordship.
Provident fund.
Yes, your lordship.
Provident fund lying in the court of your petitioner on the basis of representation by the as well as the respondent number 3 to his identification number.
Lordship, they are servicing today, lordship, but as per the direction, lordship, the respondent number 2 and 3 has been directed to serve a prior copy to the petitioner and then file it before the court, lordship. They are filing it today, lordship, and they are giving me today.
If he is in opposition.
I guess,
Report.
lordship.
report. This is not affidavit of report in the.
Oh, you want to file exception?
Lordship, I have to go through. First of all,
Do you want
they
to
have,
file exception?
yes, of course.
We will file the exception.
The report in form of affidavit has been filed on behalf of respondent number 2. কত হলো 30 ঠিক আছে এই শুনুন তো, এবার এইগুলোর মধ্যে কতগুলো আছে? এবার আপনি 31 থেকে দিন, নাহলে তো এই প্রথমের দিকে তারা সুযোগ পেয়েই যাচ্ছে, এবার 31 থেকে করবে। হ্যাঁ, ফর হিয়ারিং কোনটা? হ্যাঁ, রিটার্নেবল মোশন উপরে নিয়ে আসবে, মোশন, রিটার্নেবল মোশন, তারপর এগুলো নিয়ে আসবে, ঠিক আছে? তারপর হচ্ছে ফর যেগুলো রিটার্নেবল মোশন, তারপর তো আজকে উঠে পড়ি, আর নেক্সট নতুন ম্যাটার আর পড়া কোথায় গেল? তাহলে এই 31 কালকে কিন্তু যতজন হলো আর আমি একটু আসুন তো, এটা একটা রিমেনশনে দেবো কিনা তাই ভাব, একবার আসতে না।
ওকে ধরো
হ্যাঁ, what document has been deposited in court, you will take back after the order is signed, okay? হ্যাঁ, I am not being able to recall which document. I want one document. No, you take back later on. They have submitted certain document, form 4 and certain document, okay? And you have not submitted any document. You given rule, হ্যাঁ, ওরা জেরক্স রুল দিয়েছে, ঠিক আছে? In presence of other side, I cannot hand over. Okay, after signing the order, the document were submitted had been refunded, returned back to them. You have not submitted any document. You have rule, photocopy of the rule. Oh, you are thinking about the photocopy of Gram Panchayat administrative rule. Oh, so what? Get it copied again. Your learned friend has taken. আপনি আমারটা দেখবেন তো, গ্রাম পঞ্চায়েতের অ্যাডমিনিস্ট্রেশনের জেরক্স দিয়েছে 2004 আর 81, আর ওরা দিয়েছে